seated, please. Good morning to each one of you, and this hearing will come to order. Before the commission today is docket number 25026U, which is styled in the matter of the application of Oklahoma Gas and Electric Company to provide notice to proceed with the construction of two natural gas combustion turbine facilities in the state of Oklahoma, and for an order approving certain power purchase agreements. This hearing was scheduled by order number 2 in this docket on September the 19th, 2025. If you have to use your cell phone, please exit out into the hall and be sure and turn it off. The only violator I've ever had on this has been myself, because I failed to turn my ringer off my phone. So I have done that. So let's do, for the record, will the attorneys state their appearances and names for those persons they intend to call as witnesses? Mr. Chisenhall.
Thank you, Your Honor. Shall I stand or try to?
Why don't you go, let's get in the habit of going to the lectern. Sometimes it's better than the one seated, okay? And sometimes you have to eat it. Is it on? He's going to come make sure it's on. You'll notice that Commissioner Anderson is not here. She will join us a little bit late. She should be here by about 10:30.
Yep.
We'll take a break and allow her to get settled. So there will be three of us making the decision. Mr. Chisenhall.
Right. Larry Chisenhall and Mitchell Dennis for Oklahoma Gas and Electric Company. Today we will call Mr. Kimber Shoup, Mrs. Kelly Riley, Matthew Sherman, Christopher Lelak, and Jeremy Swartz.
Thank you. Ms. Chandler?
Dorley Chandler with the AG's office. I have with me today Michael Lewis and Michael Coots, and we will be calling Scott Norwood.
Thank you. Mr. Layson?
Good morning. Clay Layson on behalf of General Staff. I'm here with co-counsel Wes Manis. We'll be calling Jeffrey Bauer, Billy Hunter, and Michael Marchand.
Thank you. Will all the witnesses please stand and raise your right hand to be sworn? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Do you? Thank you. Be seated. Opening statements will be limited to a maximum of 10 minutes for each party. Before we move to opening statements, are there any motions or other procedural matters that need to be addressed at this time? Mr. Chisenhall, you're up for your opening statement.
Good morning, Chairman Webb and Commissioner Tate. I appreciate the opportunity to be here this morning to talk to you about Oklahoma Gas and Electric Company's application in this matter and how the adoption of the settlement agreement on the issues in this case between OG&E and the General Staff is reasonable and in the public interest. OG&E's application seeks relief under a number of statutes, but the case primarily concerns multiple projects which will provide over 990 megawatts of additional generation capacity. But even if approved, these projects will not satisfy the company's identified need, which amounts to over 1,647 megawatts by 2030. All parties in this case agree that OG&E has a significant capacity need and that these projects, if approved, will help to meet part of that need. OG&E's capacity need is not unique, as both Entergy and SWEPCO have recently sought Commission approval of new generation resources. The General Assembly declared in Act 373 that it is the policy of the state to maintain an adequate capacity of available, reliable, dispatchable, affordable, and resilient electric generation to provide for the existing and reasonably projected future energy consumption needs of all consumers of electricity in the state of Arkansas. Further, the General Assembly recognized that growing capacity needs facing Arkansas electric utilities in Act 373 by finding that most will need to construct new generation facilities in the very near future. In urging the passage of Act 373, Governor Sanders stated, and I quote, "I meet with companies all the time, and one of the number one topics they bring up is the need for affordable, reliable energy." The projects before the Commission today are the result of a robust, transparent, all-source RFP. The RFP process was overseen by an independent evaluator who reviewed draft RFP documents, attended technical conferences, monitored bid openings, received all bidder communications to ensure transparency and compliance, and reviewed final contracts. The independent evaluator concluded that the RFP was run per the Oklahoma Corporation Commission's bidding guidelines, and this process is consistent with this commission's resource planning guidelines. I was born in Memphis and grew up in the Arkansas Delta, as we discussed just a second ago, literally on the banks of the Mississippi River. I speak slowly. About 9 o'clock last night, I realized that my opening statement was about 5 minutes longer than 10 minutes. And there's a lady over here in a purplish outfit I don't want to cross with her stopwatch. I couldn't squeeze everything I had to say, which was...
Mr. Chisenhall.
Oh, you've got it.
But
I'm
I never-
sorry. Fran, I'm
Just
sorry.
for the record, I never turn it on.
Okay.
Okay? Particularly for you.
Well, I'm going to read this one then. This was the one that I had to throw away
Well, we
last
always
night.
respect you people from East Arkansas that are a little slower.
I don't know if my brain is like my voice, but I hope not. So the next best thing I'm going to do is kind of run through the settlement agreement, which resolves each and every issue between the company and the general staff. The settling of parties agreed that OG&E's decision and the initial contract cost to construct the Horseshoe Lake Units 13 and 14 are reasonable, prudent, and in the public interest. The settling parties agree that OG&E has satisfied the notice requirements of Arkansas Code Annotated 2318-104 with respect to HL 13 and 14, and the settling parties request that a commission order provides express written permission for OG&E to begin construction of the Horseshoe Lake 13 and 14 units. OG&E agrees to report to the commission in this docket on a semi-annual basis an update to the cost of HL 13 and 14 and a comparison of those costs to the project budget. The report will include all variable price, open book items, as well as the uses of the execution contingency budget. The settling parties agree that OG&E has provided notice of its intent to recover strategic investments within the meaning of Act 373 in this case. Specifically, OG&E has provided notice of its intent to recover these costs through a Generating Arkansas Jobs Act rider under Act 373. The parties agree that OG&E has satisfied the eligibility criteria provided in Arkansas Code Annotated 23-4-1305H for Horseshoe Lake 13 and 14. Specifically, a strategic investment comparable to HL 13 and 14 is not available and cannot be constructed in the state of Arkansas, thus meeting the eligibility of Section H2 of 1305. The settling parties agree that the contract costs for the 20-year 95 megawatt Black Kettle battery CPA are reasonable, prudent, and in the public interest. And the Black Kettle CPA satisfies the criteria set forth in Arkansas Code 2318-109, and we request that the Commission issue an order authorizing the company to enter into the agreement, settlement agreement. The settling parties also agree that the recovery of the additional sum on the Black Kettle CPA as authorized by Arkansas Code 2318-109E is appropriate and the public interest, and it should be based upon a 20-year U.S. Treasury yield. With respect to the Kiamichi CPA, the settling parties agree that the Commission approval of the 5-year Kiamichi CPA is not required by Arkansas Code Annotated 2318-109. Whether or not the Commission agrees with that, approval is required, or we have met the requirements of 2318-109, and the stipulating parties agree that the Kiamichi CPAs do satisfy the criteria laid out in 2318-109 and are reasonable and in the public interest. While not a contested issue in this proceeding, OG&E respectfully requests that the Commission make a determination of how it interprets the language of Arkansas Code 2318-109 in order to provide the company with guidelines on specifically when approval must be sought under these statutory provisions. This issue is addressed in the company's application and in its witness testimony. The company originally did not seek approval of the 5-year Kiamichi CPA based upon the contract not being for a period longer than 5 years, and the fact that utility statutes in the state of Arkansas are strictly construed under Arkansas law. Finally, as part of its next triennial IRP, tentatively scheduled for late 2027, OG&E will assess options and alternatives, including the feasibility of life extensions for the anticipated retirements of their plants within the next 10 years. Future load forecasts and IRPs conducted by OG&E will include additional documentation on the materialization rates of large load projects and the contractual measures used by the company to enhance forecast accuracy and certainty. In May of 2025 in Oklahoma, OG&E sought, among other things, pre-approval of the construction and cost recovery of Horseshoe Lake Units 13 and 14 and its Kiamichi Capacity Purchase Agreement. On November the 13th of this year, the Oklahoma Corporation Commission issued its order approving OG&E's application for approval to construct the units at the initial contract cost, and it also approved its reasonable OG&E's selection of the 5-year Kiamichi CPA from the all-source RFP. Importantly, the Commission in Oklahoma recognized that to contract for the identical CTs that were included in 13 and 14 at today's prices, the turbines would cost approximately $60 million more. The order, at least from the standpoint of the Oklahoma Corporation Commission, specifically addresses 2 of the 3 issues raised as contested issues by the Attorney General in this proceeding. The Oklahoma Commission, which regulates rates for approximately 92% of OG&E's customers, approved the construction of Horseshoe Units 13 and 14 and found that the 5-year Kiamichi CPA was reasonable and provided its findings based on the evidence in the Oklahoma record. While this commission is certainly not bound by the order of the Oklahoma Commission or its findings, I believe the Commission should be aware of this determination by the regulators in the state of Oklahoma. Our witnesses can provide more insight into the findings of the Oklahoma Commission and its order, which is final, if the Commission wishes to review those findings with the witnesses. In summary, OG&E believes that the settlement agreement entered into with the General Staff is supported by substantial evidence, provides appropriate customer safeguards, will result in new, much-needed generation capacity at a reasonable cost, and will increase system reliability. Thank you.
Thank you, Mr. Chisenhall. Ms. Chandler.
Chairman Webb and Commissioner Tate, on behalf of the Attorney General's office, I want to thank you for this opportunity to address you all. The Attorney General does oppose the settlement agreement between OG&E and staff because OG&E has failed to show its selection of 2 of the 3 proposed resources was reasonable and in the public interest. The 5-year Kiamichi CPA was chosen over a comparable CPA that offered a longer duration at a lower price per kilowatt hour, which would have provided Arkansas ratepayers extended protection against rising electricity costs. The HL 13 and 14 project is a self-bid chosen over higher scoring bids that is far more expensive than the near identical HL 11 and 12 project selected just 2 years prior. While these 2 selections were just pre-approved by the Oklahoma Corporation Commission, it's important to note the context. What is good for Oklahoma isn't necessarily in the best interest of Arkansas ratepayers. Oklahoma passed a law this year declaring natural gas as the preferred choice of electric generation for new generation facilities. This law weighed heavily in the background of the OCC's final order in OG&E's selection of HL 13 and 14 over higher ranking bids. Arkansas has passed no such law expressly granting a special preference for building new natural gas plants. However, Arkansas Act 373 was approved this year, requiring utilities to prioritize building new electric generation and transmission facilities within Arkansas's borders. Act 373 does not include a special preference for a given resource type and maintains the standard that a utility's resource selection must be in the public interest by selecting the best resource to fit its need. Neither the 5-year Kiamichi CPA nor the HL 13 and 14 projects meet this standard. Both resources were selected from the company's 2024 all-source RFP. Our witness, Scott Norwood, testified that he generally does not take issue with the company's underlying methodology and believes an all-source RFP is the proper way to solicit competitive bids. The RFP scores, which bid individually and independently of one another, ranking them in order of highest to lowest based on a composite score. Some bidders submitted multiple bids that used the same power plant, but those individual bids were scored independently to provide a proper comparison. Although the RFP process was generally reasonable, Mr. Norwood expresses concerns about the company's final selection of resources. The 5-year Kiamichi CPA is not reasonable because it was selected over a comparable, higher-scoring CPA. While the specifics are considered HSPI, there was a bid with a longer duration and lower price. That bid would provide a more valuable hedge against future generating capacity cost increases while also reducing costs charged to the company's Arkansas customers. The company contradicts itself in testimony regarding this concept. Company witness Kimber Shoup stated that a large benefit of the Black Kettle CPA was that a 20-year term for the capacity provides certainty over a long period at known cost. We agree with Mr. Shoup in that regard, and that's why we don't contest the company's selection of Black Kettle. But when it comes to the 5-year Kiamichi CPA, both company witnesses, Kelly Riley and Matthew Sherman, state that a shorter duration CPA provides the company with flexibility to make adjustments in its capacity mix in a reasonable time frame. Unfortunately, the flexibility comes at a cost in this case. As everyone in this room knows, energy costs are rising fast and expected to continue to rise for some time. It's common sense that a CPA that locks in a lower price for a longer period would serve as a hedge against these rising costs. The HL 13 and 14 project is not reasonable because the company's failed to justify its selection and cost. Mr. Norwood testified the self-build project ranked 26th among the shortlisted bids due to the higher costs and lower certainty that those costs are finite. Mr. Sherman responded saying that this is a misrepresentation because it lists included 14 mutually exclusive bids offered in multiple variations. Accounting for the mutual exclusive bids, Mr. Schumann says the project was ranked 12th best among the shortlisted bids. He misses the point. An RFP scores and evaluates bids independently. Each bid is scored against one another, including those offered in multiple variations. This is a standard feature of RFPs. Additionally, saying the company chose the 12th best bid is not very helpful because it shows a large gap in the company's analysis. This gap suggests the company evaluated criteria outside the RFP process. The company's rebuttal and surrebuttal failed to supplement the record in this regard. The expected price of the company's chosen natural gas CT facilities has also increased substantially in the last 2 years. Mr. Norwood testified that the contingency and owner's cost increase from the HL 11 and 12 project and this project are of particular concern since the two projects are virtually identical. The company is expecting its Arkansas customers to cover all of these costs under the Generating Arkansas Jobs Act rider. The General Assembly made its intent clear under the Act. A utility shall give priority to strategic investments in new electric generation and transmission facilities located in Arkansas. This plain language shows the General Assembly intended the rider to facilitate economic growth and activity in Arkansas through utility infrastructure investments within the state. In other words, the General Assembly created a presumption that utilities make strategic investments within these borders if they want to recover costs under the rider. To overcome this presumption, a utility bears the burden of showing it qualifies under one of the exceptions. There are two exceptions relevant here. First, a utility may demonstrate that a strategic investment located outside of Arkansas provides greater benefits to utilities' Arkansas customers than a comparable strategic investment located in Arkansas. Second, the utility may demonstrate that a comparable strategic investment is not available or cannot be constructed in Arkansas. The first exception requires a two-pronged comparison. OG&E must present evidence qualifying the benefits to Arkansas customers from out-of-state strategic investments against comparable strategic investments within the state borders. Mr. Shoup testified that the company's Arkansas customers will enjoy significant benefits from the savings of locating HL 13 and 14 at an existing site. However, the magnitude of these benefits is questionable because of the cost estimate for the project is significantly higher than other bids and the HL 11 and 12 project. Additionally, the company puts forth no evidence quantifying the potential job growth, economic development, and tax revenue that could result from making investments in Arkansas. Regarding the second exception, Mr. Shoup stated on direct that there was no comparable strategic investments available in Arkansas because no projects located in Arkansas were submitted in the RFP. However, Mr. Shoup later acknowledged one bid clarified on rebuttal that the only conforming bid for a project in Arkansas is not comparable within the meaning of Act 373, but it ranked lower than the project. Staff witness Mr. Bauer testified on direct that the lower ranking generally supports the company's argument, but that he had reservations about making legal conclusions while docket 24102U continues. These points fall far short of the affirmative evidence required under the statute. OG&E chose to self-bid in the 2024 RFP without considering new generation in Arkansas. Further, other utilities have recently been able to submit applications for new gas-fired CT generation resources to be built here in Arkansas. To summarize, the settlement agreement between OG&E and staff is not in the best interest of OG&E's Arkansas customers because its selection of two of the proposed resources was not shown to be reasonable, and the HL 13 and 14 project fails to satisfy the satisfactory requirements of the Act 373. Thank you.
Chairman Webb, Commissioner Tate. For the commission in this docket is OG&E's application related to two natural gas combustion turbine facilities in Oklahoma, Horseshoe Lake units 13 and 14, as well as two capacity purchase agreements, namely the Black Kettle CPA and the 5-year Kiamichi CPA. Multiple factors influence the increasing capacity needs seen in OG&E's 2024 IRP and the 2025 IRP update. It's largely driven by rapidly escalating load growth projections, including forecasted growth related to new large load customers, planned resource retirements, and tightening SPP capacity accreditation requirements, which increase the amount of accredited capacity OG&E must carry while reducing the amount of capacity credit its existing resources receive. While these factors clearly point to an upward trend in capacity need, after an initial review of the application, General Staff Witness Jeff Bauer concluded in direct testimony that OG&E had not fully supported the need for the projects for which it is seeking approval here in this docket. First, Mr. Bauer stated that OG&E had not provided specific information on prospective customers to justify OG&E's higher load growth projections, thus making it difficult to assess whether that load growth will actually materialize as expected. The possibility of the cancellation or delay of a large customer interconnection imposes risks to utilities and ratepayers. Staff recommended that OG&E supplement the record by providing additional details on its large load customer forecast, including details on the level of certainty related to the realization of large loads. In his rebuttal testimony, Mr. Bauer found that the additional information the company had provided regarding its load forecasting as it relates to large loads generally addressed his concerns. Mr. Bauer, however, cautioned that experiences of other jurisdictions have shown that there remains some risk related to the materialization of large loads. With regard to retirements, in his direct testimony, Mr. Bauer expressed that there was some uncertainty over the timing of the need for incremental resources due to lack of support in the application regarding when or if certain retirements will occur. To the extent that assumed unit retirements are key drivers of need for incremental resources, staff recommended that the company provide additional analysis to determine whether retirements are needed or whether life extensions may be more economical capacity options. After reviewing the company's rebuttal testimony on this issue, Mr. Bauer generally agreed with the company that changes in retirement timing do not affect the need for resources in this case. However, staff continued to recommend the company conduct unit disposition and life extension analyses. Overall, in rebuttal, Mr. Bauer concluded that the additional information and context provided by the company supports a demonstration of need for the resources at issue in this case. In recognition of staff's recommendations regarding the uncertainty of future large loads and their impact on forecasted capacity need, the settlement agreement contains a commitment from OG&E that its future load forecasts and IRPs will include additional documentation on the materialization rates of large load projects and the contractual measures used by the company to enhance forecast accuracy and certainty. Next, in recognition of staff's recommendations regarding retirements, OG&E has also agreed, as part of its next triennial IRP, which is scheduled for 2027, to assess options and alternatives, including the feasibility of life extensions for anticipated retirements within the next 10 years. Alongside these commitments by OG&E, the non-unanimous settlement agreement recognizes OG&E's capacity need that supports approval of the projects. Next, design and administration of the RFP. Following its 2024 IRP, OG&E issued 2 RFPs in 2024. 1, the 2024 Bridge Capacity RFP, and 2, the 2024 All-Source RFP. The all-source RFP is what yielded the 3 projects that are the subject of this proceeding. The all-source RFP was designed in a way such that it was not limited to any specific type of technology, fuel source, or specific generation location or type of capacity contract. An independent evaluator reviewed the draft RFP documents, participated in technical conferences, virtually attended bid openings, received all bidder communications, and monitored bid evaluations. Mr. Bauer, in his direct testimony, concluded that the RFP design and administration appear reasonable and that the RFP was supported by the involvement of an independent evaluator and that it received robust participation from a range of bidders reflecting a variety of resource types. Turning to the individual projects, first we look at Horseshoe Lake Units 13 and 14. In its application, OG&E provides notice and requests approval to commence construction of Horseshoe Lake Units 13 and 14 on property near Oklahoma City pursuant to 23-18-104. OG&E also seeks a finding that the company acted prudently in its decision to construct that project and that the initial contract costs are prudent. Mr. Bauer raised in direct testimony concerning the sufficiency of OG&E's RFP process that led to the selection of Horseshoe Lake. He raised some concerns, and he concluded that additional justification was necessary. He also requested additional information to justify the cost increase between the Horseshoe Lake project and the prior Horseshoe Lake 11 and 12 project that is the subject of Commission Docket number 24-102U. In rebuttal, the company provided that a number of higher-ranked projects from the RFP were unavailable, inexecutable, or much higher priced than originally offered. The company also noted the portfolio of selected projects, including Horseshoe Lake 13 and 14, met the objectives of the RFP, including capacity obligation, expected cost to customers, exposure to risks, fuel and technology diversity, reliability and resiliency, adaptability, and portfolio age. Mr. Bauer concluded that the company provided a reasonable rationale for the selection of Horseshoe Lake 13 and 14, explaining that the selected portfolio represents a diverse group of projects, including solar, battery, a short-term capacity contract, and a long-term utility-owned resource. In addition, as noted by the company, the project will allow the company to make use of expansion options at the Horseshoe Lake site. Regarding the increases in costs between Horseshoe Lake 11 and 12 and now 13 and 14, the company provided details on the various elements of the cost increase and also identified certain mechanisms by which the project may ultimately come in under budget, noting that the 11 and 12 project costs are currently trending lower than the original estimate. Mr. Bauer recommended in his rebuttal that the Commission require measures to help ensure that all possible savings are sought for the benefit of OG&E's customers. He specifically recommended utilization of an independent monitor. The non-unanimous settlement agreement includes a commitment from OG&E to update the Commission in this docket twice a year regarding the costs of 13 and 14. Staff settlement witness Mr. Marchand explains how this is a reasonable compromise to staff's independent monitor recommendation without OG&E's Arkansas ratepayers having to incur the full cost of an independent monitor. Notably, the Oklahoma Commission recently approved Horseshoe Lake's Units 13 and 14 without requiring an independent monitor, finding that OG&E properly and appropriately bid the project into a competitive procurement process and included prudent and reasonable costs with its bid, and therefore should not be subject to a specific cap or other measure. Next, OG&E is also seeking a finding that Horseshoe Lake 13 and 14 are eligible for recovery through a Generating Arkansas Jobs Act rider. The Generating Arkansas Jobs Act, or Act 373 of 2025, authorizes a new mechanism for the cost recovery of strategic investments, which provides for recovery of a return on construction work in progress plus operating expenses during construction, and return on rate base plus operating expenses once the strategic investment is complete and in service. Since Horseshoe Lake 13 and 14 project is not located within the state of Arkansas, Arkansas Code Section 23-4-1305H applies, which requires utilities to give priority to strategic investments that are located in Arkansas unless one of three exceptions are met. Mr. Bauer stated in his testimony that the company's RFP results generally support the company's argument that a comparable strategic investment is not available or cannot be constructed in Arkansas as set forth in the exception of 1305H2. Consistent with the settlement agreement between staff and OG&E involving similar facts related to the Horseshoe Lake Units 11 and 12 in Docket 24-102U, staff and OG&E are in agreement that 1305H2 has been met in this case as well. As noted by both Mr. Bauer and Mr. Marchand, supplemental testimony was filed by parties in 24-102U in response to Commission questions related to Section 1305H, subsequent to the filing of the settlement agreement in that case. The Commission has not yet decided that case. Next, we have the Black Kettle 20-year capacity purchase agreement. Black Kettle is a new battery energy storage system project located near Woodward, Oklahoma. OG&E seeks a finding that the 20-year term Black Kettle CPA complies with Arkansas Code 23-18-109C. In direct testimony, Mr. Bauer raised a concern regarding the project related to cost uncertainty, which the independent evaluator had made note of in its report. In rebuttal, OG&E provided information responsive to Mr. Bauer's concern. Mr. Bauer concluded that taking into account how Black Kettle scored in the bid evaluation, along with the protections mentioned by the company in rebuttal, the project should be approved. The non-unanimous settlement agreement supports such approval. OG&E also requests the Commission authorize the recovery of an additional sum related to Black Kettle under 2318-109E. After staff initially declined to support an additional sum associated with the Black Kettle CPA due to concerns raised by Mr. Bauer in direct, staff witness Billy Hunter recommended in rebuttal that the Commission authorize an additional sum to be calculated based on a 20-year U.S. Treasury yield as opposed to OG&E's proposed use of its weighted average cost of capital. Mr. Hunter's recommendation is reflected in the non-unanimous settlement agreement. And finally, we have the Kiamichi CPA. It's a 5-year CPA that secures 300 megawatts for each of the first 2 years and 450 megawatts for each of the latter 3 years of the existing 1,200 megawatt Kiamichi natural gas facility located in Pittsburgh County, Oklahoma. OG&E seeks a declaratory order finding that pre-approval of the Kiamichi CPA and related cost recovery is not required under Arkansas Code 2318-109C because it is not for a term that exceeds 5 years. Mr. Bauer pointed out in his testimony that the Kiamichi CPA runs consecutively with another Kiamichi CPA that results in the practical effect of a CPA that is longer than 5 years. He states that if the intent of 109C is to ensure that the Commission has an opportunity to review and approve long-term utility commitments, the company signing separate agreements of 5 years or less to avoid this review process, whether intentional or not, would appear to set a bad precedent. Nonetheless, Mr. Bauer ultimately supported the inclusion of the Kiamichi CPA as a component of the portfolio of projects selected from the RFP. The settlement agreement provides that the settling parties agree that the Kiamichi CPA is reasonable and in the public interest, regardless of whether approval is required under Section 109C. Staff asks that the Commission grant the motion to approve the non-unanimous settlement agreement filed by staff and OG&E. Thank you.
No one has signed up on the sign-up sheet to make public comment. Is there anyone in the room wishing to make a public comment concerning this application? Seeing none, we will move on. There was a non-unanimous settlement in this matter. The pre-filed testimony is admitted into the record. It will not be duplicated in the transcript of today's live hearing. The witnesses in the main case will be called first, and then we will address the settlement and settlement witnesses later. Have any parties waived cross-examination of any witnesses? Mr. Chisenhall?
Yes, Your Honor, we have waived cross of all staff witnesses.
All staff witnesses, okay.
Mr. Chair, staff has waived across
Of OG&E witnesses, okay. Attorney General?
We've not waived any.
You have not waived any?
No,
Correct. Thank you. Also, please note the Commission's long-standing hearing rule will be in effect during the hearing, meaning that once the witness has been tendered for questioning by the Commission, further redirect of the witness by counsel will not be permitted. Further, the parties are reminded that this case may include protected information, including highly sensitive protected information. Members of the public are advised that the hearing room may need from time to time be cleared, with the exception of persons who have signed the proper affidavits of non-disclosure. Parties are advised to inform the Commission if and when a party intends to reference confidential information, in which case the Commission can determine whether to go in camera. and the live stream will be discontinued during those times as well. Are there any motions or other procedural matters that need to be addressed at this time? Seeing none, I want to make a comment that, with all due respect to our sister organization, the Oklahoma Corporation Commission, and its chairwoman, the Honorable Kim Davis, we are a co-equal body and not bound by any decision of the Oklahoma Commission. It's certainly not supreme to the Arkansas Commission, and we are co-equal bodies making our own decisions. Thank you all for your information, and I believe we have their decision as well. Mr. Chisenhall, you may call your first witness.
Thank you, Mr. Chairman. We will call Mr. Kimber L. Shoup.
And you'll be just seated. You can pick a chair there, either one, and yes. Be comfortable and take your time.
Talk slowly. Not as slow as you.
That's Arkansas River water also.
It's wrong color.
Hopefully not, actually.
It's the wrong color. Would you state your name, position, and business address for the record, please, sir?
Hi, my name is Kimber Shoup. I'm the Director of Regulatory Affairs at OG&E, and my address is 321 North Harvey in Oklahoma City, Oklahoma.
Are you the same Kimber L. Shoup who submitted direct testimony in this docket on July the 25th, 2025, rebuttal testimony on October 22nd, 2025, rebuttal testimony on November 17th, 2025, and settlement testimony on November 25th, 2025?
Yes.
Do you have any changes or corrections to this testimony?
No.
I would tender the witness for cross-examination.
Thank you, Mr. Chisenhall. Mr. Lewis?
Thank you, Mr. Chairman. And I actually did have a question real quick before I get into my questioning. You indicated that we would be taking the general witnesses first and then testimony witnesses second. He serves as
Settlement witness.
settlement witness.
Yep,
Yes, sir.
yep.
He serves kind of as both. If my questions are pertaining to settlement, would you like me to hold them or go ahead? How would you like me to proceed?
If it makes it easier, let it go ahead.
Okay.
Okay.
The
But we're
majority of
not
my,
considering settlement at this point, okay?
okay. Thank you, Your Honor. Mr. Shoup, what's your role with OG&E?
I'm the Director of Regulatory Affairs.
Okay, and just generally speaking, what does that role do? What does that mean?
I oversee all of the regulatory matters the company has in both Oklahoma and Arkansas, and some in the Federal Energy Regulatory Commission. Before my current role, I was served as an attorney for the company for a number of years, since 2006.
Okay, and so you're very familiar with filings both Oklahoma and here in Arkansas then?
Yes.
Okay. The settlement testimony that was filed by Mr. Marchand in this matter, it referenced an Oklahoma order, and we've discussed it a little bit up to this point. And it was regarding the same resources that are at issue here today, correct?
That's correct.
Okay. And did you file testimony in that Oklahoma case as well?
I did.
Okay. And did you file settlement testimony in the Oklahoma case in support of a non-unanimous settlement agreement?
Yes.
Okay. In the joint stipulation and settlement agreement that was filed by OG&E in the Oklahoma case, did OG&E agree to a cost cap in that case?
Yeah, actually, we did. It was part of a global settlement related to this case and included the receipt of construction work in progress in that case. Actually, that settlement agreement was not approved by the commission. The commission made its own calls of balls and strikes in that case.
Okay.
However, Commissioner David was supportive of the settlement agreement.
Okay. And your settlement agreement that you proposed that was rejected, did it also have a cap on the contingency cost?
Yes, it did. It had an individual cap on contingency costs, but again, that was a settlement agreement that wasn't accepted.
Okay. And the Arkansas non-unanimous settlement agreement, does it have any cost cap provisions in it?
No, we have an approval of the bid amount was roughly $506 million. That's what we bid into the project. We're confident that those costs will be the final cost of the project. That is, we would be limited to that recovery in Arkansas. But of course, if we have savings, if we don't see the contingency costs, then the recovery would be lower. And if our costs go up, we would have to come before this commission and seek a prudence review of any costs in excess of the $506 million before we can get recovery of those costs.
But you did deem it necessary in Oklahoma to agree to a cost cap.
But again, that wasn't approved because that was a settlement that was
That
rejected
wasn't my
by the
question. I
commission.
asked if you agreed to it.
We did, yes.
No further questions.
And staff has waived cross. Any redirect?
Very short. Mr. Shoup.
Go to the lectern, please. We want to see your
Old
handsome,
habits die hard.
we want to see your handsome face.
I do appreciate that.
The viewing audience wants to see that, okay?
Mr. Shoup, Mr. Lewis
Pull your mic down, there you go.
was speaking to you about having a cost cap in this proceeding. Do you happen to have a copy of Act 373 with you handy?
I do not.
Mr. Chairman, may I show this to him? It's a
You may.
Would you read that section that's 1305B3 for me, please, sir?
An investor-owned electric utilities or an investor-owned natural gas utilities recovery through the rider shall be limited to the amounts identified by the investor-owned electric utility or an investor-owned natural gas utility in the proceeding in which the commission approved the strategic investments unless a greater amount is subsequently authored by the commission.
So would you agree that in addition to stating that you would only request $506 million, that $506 million effectively works as a cap under Section 1305B3?
That's how I would interpret that, yes. And of course, it does say if it's subsequently authorized by the commission, so the commission can authorize an amount different from that ultimately if it's proven to be prudent and reasonable.
And you are still sticking with 506,000.4 million, whatever.
Yeah, that was the bid price, and we have not seen an increase in that cost since the bid was submitted and we entered into final contract negotiations. So that the number has been consistently at that number.
Thank you. That's all I have.
Thank you, Mr. Chisenhall. Mr. Tate, we'll go to commissioner questions. Is there any recross?
No, sir.
Thank you.
Thank you, Chairman. Can you guys hear me okay?
Yes, sir.
All right. I'm going to start by first saying I appreciate OG&E limiting the amount of confidential information in this case. I am going to put it on you, Mr. Chisenhall, that if we get into that territory, you'll jump up and flag us.
I will try, Your Honor. I've got pink pages marked over here. Just tell me where you are.
You let
Well,
us know, and we'll
I'll
Go
try to
ahead,
give you an
Mr.
indication
Tate.
of the direction I'm going so you'll know whether an answer might be fall in that category.
Very well.
Mr. Shoup, unfortunately, you're the first witness, so you're probably going to get a lot of questions that you may want to defer to your colleagues, but we'll start with you and you can point us in the right direction. Is that
No
all right?
problem.
Can you tell me the purpose of the RFP, what exactly you were looking for?
Yes, so what we do usually is we'll have, the processes are in Oklahoma is we have an IRP. It's the same IRP that we file here in Arkansas. And we establish our need based on the IRP. And then we issued an all source RFP in order to seek the the needs or to fill the needs that were identified in the IRP. And when I say all source, we didn't limit it to any type of technology or any type of a contract. So we had capacity purchase agreements, power purchase agreements, power supply agreements, because we had the possibility of a self-bid or an affiliate bid in this case, we wanted to make sure that we created a non-preferential and non-discriminatory process. So because we had people within the company that were going to be on both sides, both on the evaluation team and the bid team, we created a code of conduct to separate those people so we could prevent communications that were outside of the view of the independent evaluator and to make sure that we did this above board. And so we also didn't want to direct the bid team to tell them what we wanted. We wanted it to be completely separated. And so anyway, we had that code of conduct, and then we go through the process. It's a very detailed competitive solicitation process under the rules in the Oklahoma Commission. So we went through that process. We had the independent evaluator. We opened the bids in the view of the independent evaluator. They oversee all the communications between the bidders and the company. And then we did the evaluation process, which they then reviewed and issued a report. Does that answer your question, Commissioner?
Sort of. The need specifically identified that drove the purpose for the RFP was what? Capacity specifically?
We identified a need for capacity, and then the RFP was designed to identify what generating capacity we were going to select in order to meet that need. We not only are looking for the lowest reasonable cost projects, but as witness Kelly Riley will explain, is we also identified objectives in the IRP document. That needs to be timely with regards to when our need is going to be there, because the need is going to grow over time. We want to make sure that we have dispatchable generation in addition to other types of generation. We want to make sure that we have a good, healthy mix of different types of generation. So that was all detailed in the IRP. So the RFP is looking at not only the lowest reasonable cost project, but also projects that conform to the objectives of the resource plan.
So did the RFP identify those objectives as well, or was it just focused on capacity?
The RFP was, well, you could probably ask Kelly Riley. She can go through the details of the RFP process.
Okay. Do you know how many RFPs you've issued in the last 5 or 6 years?
Well, we've done a series of short-term RFPs, like bridge capacity RFPs. It's been several. Again, Witness Riley can kind of walk through. We had an IRP in 2021 and an all-source RFP in 2022. Then we had an IRP again in 2024, followed by an RFP in 2024. So I lose track because we've done a ton of them. But Witness Riley can go through those in detail for you.
Okay. You requested, OG&E requested to recover costs through construction work in progress in Oklahoma. Is that correct?
That's correct.
And that was not approved?
Yeah, it's a little bit confusing because we asked for it, and subsequent to our application, they actually what was made effective was a new law in Oklahoma that requires it for new natural gas facilities. And so, because we had filed prior to the effective date, and on that technicality, the commission said no, but these actually meet the requirement under the law. So we anticipate filing again for CWIP in Oklahoma for those facilities.
For these facilities?
Yes.
So that'll be a new application or an appeal of the order issued by the commission?
It would be a new application.
Okay. So what the commission authorized in the order is for those costs to go through a generation capacity rider. Is that
Yes.
correct? How does that work in Oklahoma?
Well, if we don't have CWIP, what it would do is these projects would be constructed, and we would place them into the rider as soon as they became commercially operating. So that would be when they're placed in service, that's when the rider recovery would kick in. And these, for Horseshoe Lake 13 and 14, that wouldn't be till 2029, I believe.
Sorry, their rider is a little new to me. I wasn't familiar with it. You have roughly 18 months under that rider to recover, and
Yes.
then what? No recovery until a rate case and it's put in base rates?
The rider would expire, and we would be, in order to continue recovery of those projects, we would have to file a general rate case.
Okay.
And so we would get 18 months essentially, and that means we could have a full year of operations of the plant and then file the rate case, and a rate cases in Oklahoma takes 6 months. So
Okay.
you would have a full year of commercial, O&M expense related to that particular facility.
Yeah, before you
So
need
you,
to file.
so
a
you
case.
could have that to be reviewed,
Sure.
and then it would go into rates.
Now, they only authorized a specific amount through the rider, right? Was that the amount identified for the facility?
The $506 million, yeah.
So that operates sort of as a soft cap as well, right?
Yeah, it's the same way. If for some reason we go over that amount, then we would have to prove up the prudency of those additional costs. If we bring it in under budget, those costs would be automatically, the cost flowing through the rider would be automatically reduced.
I was a little confused reading through the testimony. I thought in your direct, you stated that there were no Arkansas projects responsive to the RFP.
Yes.
Looking at follow-up testimony, it appears there was at least one project identified. Can you clarify for me?
Sure. Yeah, so there was one that was a solar facility. It wasn't comparable to the Horseshoe Lake 13 to 14 gas units.
But that was a project responsive to the all source RFP.
Yes, and it was a solar facility, I believe, but it was much lower ranked, so it wasn't even close to being in the money.
Mr. Chisenhall, I've got questions about that specific project. I don't know if that's going to get into confidential territory.
You're treading on thin ice. I think we probably.
Let me see if I've got anything else before we go down that road.
And Commissioner, I'll just say that I don't have any other. You
You
could
don't
probably
have any
ask-
additional details?
That's
Okay,
all I
I'll
know.
hold that
You've
then.
exhausted me on that particular bid.
OG&E used an independent evaluator as part of the RFP.
Yes, and it's required under the commission rules in Oklahoma. Sorry.
You'll have to remind me how costs are allocated between the two jurisdictions. Is that done on like a production demand basis, or how do you determine what costs get allocated to Arkansas versus Oklahoma?
Yeah, we use a jurisdictional allocator, and I think it was somebody mentioned earlier. It's about 92% Oklahoma and about 8% here, subject to check.
Is that the allocation, or is that roughly just the number of customers? Because those can obviously be different.
It's about the same.
It's about the same?
Well, I think subject to check. I think the jurisdictional allocator for Arkansas is about 8%, but it's changing.
So as part of your IRP process, you guys outlined when large loads work its way into the model based on some sense of, you guys feel those projects are more likely to happen than not before they enter the model based on certain milestones, I guess, with those large loads. Is that correct?
Yes. The way I understand it, and witness Schwartz can kind of talk about this specifically, but we are trying to be as conservative as possible when we include those large loads into our load forecast. We're only focusing on the loads that are very certain to come. They either have given us a significant kayak payment, for example, or they've signed an agreement, committing themselves to our jurisdiction. What we don't want is to plan around too speculative loads. So we want to make sure that, A, they're an existing customer that maybe has indicated an expansion, they've given us a large kayak payment, or they're committing themselves through some kind of long-term agreement. And in that case, we include it in the load forecast, and then we plan around it.
Are any of those customers, large load customers that you've identified in Arkansas?
I don't think I can say. I think you might have to ask Mr. Schwartz about that. But
Okay.
I mean, ideally, we would like to see growth in both jurisdictions.
Sure. But I understand you guys don't build it, like you said, you don't build it into the model until you've got some level of certainty that they're going to materialize.
That's correct.
You anticipate a fair amount of growth within your footprint. If a lot of that growth happens, or a majority of that growth happens in Oklahoma, how is that going to affect the allocator?
So the amount of costs that are allocated to Oklahoma will grow, and the costs that will be allocated to Arkansas will shrink. And so you want to design your rates to make sure that the cost causer pays for the costs. And so as you increase that allocator for Oklahoma, those costs will shift over there, and you'll see a reduction in rates for Arkansas customers. Now, it could be the opposite. If you see a large increase in, let's say, in Fort Smith, they see a huge data center go in, then that might mitigate some of those effects for the allocator change.
And what is the process for that allocator to change? Does that only occur in rate cases?
Well, yes, we had in the last formula rate that is no longer being updated for the company, I believe the jurisdictional allocator would change year to year. So every year, as we updated those rates, we would look at the jurisdictional change that had happened in that year, and there would be it would alter that jurisdictional allocator.
Okay.
But that we are no longer updating the formula rate. We would have to file a new rate case in order to institute that formula rate going forward.
If we don't approve, or we determine that Horseshoe Lake 13 and 14 are ineligible for recovery through the Generating Arkansas Jobs Act rider, how will those costs be recovered? Is that going to require OG&E to come in for a base rate case?
Well, we still have Arkansas still has a need for capacity, so they are going to we would need to have an amount of capacity for Arkansas's customers because they have to pay their fair share of the capacity needs that we have. So what we would have to do is probably go out and procure some other form of generation specifically for Arkansas customers and direct assign those costs.
Let me clarify for a second, because there's two separate questions there. Oklahoma's already approved this project. If we don't approve the project, do you anticipate Oklahoma taking the remainder that would have been allocated to Arkansas?
I don't know the answer to that. I think we would have to talk to the Oklahoma Commission about that. It would probably, if Oklahoma was to accept 100% of this, it would decrease the amount of additional capacity needs that Oklahoma would have to pay for, and then we would have to contract for something specific for the Arkansas jurisdiction and directly assign those costs to you. I'm not sure what that cost would be.
The second question, which was my initial question, if we approve the projects, but we find they are ineligible to go through the rider, how would you recover those costs? Would that require a rate case?
Yes, we would have to do it the traditional way, where we would come in and seek recovery through a rate case or a formula rate process to recover those costs.
Now, the two capacity purchase agreements that are the subject of your application, I think it was your testimony, you identify that you're not We've not asked for a specific method for cost recovery of those at this time. How do you anticipate recovering those costs?
Well, there's a couple ways to do it. We have filed for, in the past, we have asked for similar short-term capacity agreements. We sought one of three options. One is to kind of push those costs into a regulatory asset, or to amend the ECR, or to do it through some kind of separate recovery mechanism, some other rider. We kind of teed up all three options. In the previous proceeding, we settled to the option of doing a regulatory asset. However, we could do any of those three options. I believe the commission has indicated a preference for amending the ECR. That's the way we do it in Oklahoma. Those costs will flow through our fuel clause in Oklahoma. So we're open to that as well.
But you haven't identified at this point how you intend to recover?
We have not.
Okay. Have you identified when OG&E intends to file its next rate case?
We're still looking at that, but we're not quite sure yet.
You
We haven't announced.
You have a rough time frame? Are we talking about 2026 or later?
I think originally we were looking at 2026, and we've got a lot of things going on, so we're trying to assess when the next rate case would be filed.
I think that's all I have at this time, Chairman. Depending on whether we get, whether the remaining witnesses are the appropriate witnesses, we may need to call up Mr. Shoup at the end.
We're going to take a 10-minute break, and we will pick back up with you after.
Thank you.
Commissioner Anderson has joined us. But Commissioner, do you have any questions of Mr. Shoup?
I do not right now, thank you.
Mr. Shoup, I have a few questions, and if you cannot answer them, please let me know. The construction of these projects will involve how many people? Do you have that information?
I do not.
Okay.
I'm
You
sorry.
have nothing related to people and working at the facility?
I don't, but I think witness Lilac, who is the director of our major projects, could probably shed some light on the construction effort that would be undertaken for these projects.
Okay. Let me shift then to another topic.
Okay.
You mentioned kayak. What is kayak to you? How
It's
do you
a-
define it?
Yeah, it's contribution in aid of construction, and it's if we are building out to a specific large load customer and we have to undertake a significant build out of the transmission and distribution system, we require customers to pay a contribution in aid of construction in order to construct those costs. The reason we do that is because they're incurring the costs because of their new development, so we don't want those costs necessarily being pushed onto other customers. So we usually require a kayak payment.
Is there a percentage that you require, or is it?
I don't know if I can answer that. I think it depends on the size of the facility and the types of infrastructure that
And
we're
is that
constructing.
applied to those construction costs, those kayaks?
Yes, and so they would provide that amount, and then those costs would not be included in rates for other customers.
And right, it would help offset rates
Correct.
for the rate payers of Oklahoma.
Yeah, or Arkansas.
Yes, or Arkansas. Okay. Mr. Tate, those are my questions. Do you have anything further?
Yeah, just a couple things. I imagine you're probably going to point me to another witness for a few of these, but just to clarify, well, I'll start with what the chairman was asking about in relation to kayak. Were there any kayak payments that apply to the Horseshoe Lake projects?
No, I think generally the kayak payments are limited to the build out of the transmission and distribution system. So if a new substation needs to be constructed or something like that, but it's not related to generation costs because all customers are benefiting from the generation that we need.
So you don't generally take kayak for generation.
We usually do not know.
What is driving the capacity need for OG&E?
I would say Witness Riley can probably talk about this in greater detail, but I say it's a combination of the evolving requirements of the SPP. The SPP has evolving resource adequacy requirements that are getting stricter. In addition, they're changing the accreditation of certain capacity facilities. And then in addition to that, we're also experiencing large load growth.
But you can't specifically identify where the load growth is occurring?
Well, I think we are seeing a lot of load growth in Oklahoma. We're hoping that we'd see also load growth in western Arkansas, including Fort Smith. And so we're continuing to hopefully we've got an economic development team that's out there trying to develop all of our service territory and to bring economic development to our entire service territory, including Arkansas.
And who is the correct witness to ask about those economic development projects or economic development efforts?
Well, Witness Schwartz is here to talk about our load growth in particular, so he might have some details around the load growth that we're experiencing across the service territory.
Before we move on, I've got questions about the request by OG&E for a declaratory order on whether the CPA, the 5-year CPA, requires our approval.
Mhm.
Are you the appropriate witness for that?
Yes, sir.
So walk me through the RFP. Did you do both the short-term bridge and the all-source RFP at the exact same time?
I don't believe so. I think they were, I think the bridge RFP preceded the all-source RFP. But witness Riley can talk about that. She conducted those RFPs, so she's probably in the best position to explain the differences and the timing of them.
The 1-year CPA that was selected under the bridge and the 5-year that was selected here is for the same resource?
It's from the same facility, but they were in different RFPs. One was the
Sure, I understand they were
short-term- yeah.
selected and they're subject to different contracts, but it is the same resource.
Yes, it is. It's the Kiamichi plant in southeastern Oklahoma, which is owned by a company called Tenaska.
And what is the overall capacity that is being subject to the 1-year agreement?
Subject to check, I think it's 450 megawatts, but witness Riley has those details.
And do you remember for the 5-year, I know it changes partway through the contract, but do you remember how much capacity is being purchased as part of that agreement?
Yeah, it's initially 300 megawatts, and then after the third year, it goes up to 450 megawatts.
Okay. So it's OG&E's position that separate contracts, one for a year and one for 5 years, doesn't trigger the requirement for our review because they are separate.
That's our interpretation, but that's why we brought this to the commission and are seeking a declaratory order, because that's our belief, but we wanted to make sure that we were transparent, and we brought this issue to you to make the decision.
Yeah, and I want to be clear, I'm not suggesting anything was done intentionally to avoid our review. You wouldn't be asking for a declaratory order, I think, if that was the case.
Right.
But I am curious what OG&E's position is as far as contract extensions or renewals or just separate contracts of 5 years that kind of that are in succession, I guess, right? So you can understand the concern we might have that a blanket order that says anything less than 5 years or 5 years and less isn't subject to our review. It would almost incentivize to avoid review just doing successive 5-year contracts. And what is OG&E's position if the contract was for 5 years, but then you were permitted to renew it for another 5 years? Would that be subject to our review?
I hadn't thought about that. It seems like that would be a contract that would be subject to your review, because it could go longer than 5 years, but I haven't looked at that, and I don't believe that's a provision in this contract.
So to avoid that, just doing separate 5-year contracts would be sufficient then?
I'm sorry, say that again?
So to avoid that, if you think maybe that would trigger our review if it had the ability to be renewed, just doing separate 5-year contracts then would be sufficient to avoid our review?
I guess, but that's not, I mean, I can say that that's not our intention. We're not trying to avoid commission review of anything. So that's why we filed it in this case, is we wanted to make sure you're aware of it, and if it's something that you think you should approve on the front end, we want you to be able to do that.
That's all I have, Chairman. Thank you.
Mr. Shoup, I've got a few more questions. Are these, there's 3 projects here. There is Horseshoe Lake 13, 14, and then there's Black Kettle.
And the Kiamichi, well, yes, and then also the Kiamichi contract, subject to Commissioner Tate's
Gotcha.
question.
Are any of these projects necessary because of a large load in Arkansas?
No, I would say that all of the projects are needed because of the global need of OG&E's service territory across both jurisdictions.
Which is 92% in the state of Oklahoma.
That's correct.
only 8% in Arkansas.
roughly.
Are
yes.
you aware, and maybe it'll be your, recruiter, for lack of a better term, are you aware of any large loads looking in your service area in Arkansas?
I'm sorry, I don't have that information.
Okay. Ms. Anderson, do you have any questions?
I do not, thank you.
Okay. Mr. Tate, you may stand down.
Thank you very much.
Thank you. Mr. Dennis, I believe you're calling the next witness. I know you'll do a much better job than Mr. Chisenhall.
Oh, goodness.
He speaks faster.
That's important.
I don't know about that, Your Honor, but he's a tough act to follow.
Thank you. Thank you.
OG&E calls Kelly M. Riley. Yeah. Please state your name, position, and business address for the record.
My name is Kelly Riley. I'm the Director of Resource Planning for OG&E. And my business address is 321 North Harvey in Oklahoma City.
Are you the same Kelly Riley who submitted direct testimony and exhibits in this docket on July 25th, 2025, and rebuttal testimony on October 22nd, 2025?
Yes, I am.
Do you have any changes to your filed testimony?
I do not.
Pass the witness.
Thank you, sir. Mr. Lewis.
Thank you, Your Honor. Good morning, Ms. Riley.
Pull that mic up just a little bit. Yeah, there you go.
Is that better?
That's good. That's thanks.
Ms. Riley, do you have a copy of your rebuttal testimony?
I do.
Would you mind turning to page 5 of your rebuttal testimony and reading line 10 through 20?
I'm sorry, did you say page 5?
Yes, ma'am, of your rebuttal,
And what were the lines?
10 through 20.
Your Honor,
Oh, excuse me. Yes.
this is going to include HSPI materials.
Thank you, Mr. Dennis. Yes,
want
that
to-
is.
okay,
Yes, can we clear the room? I appreciate it.
Yeah, let's go in Cameron, and Madam Reporter will need to note that we're going in Cameron, and record, okay? You may proceed.
Okay, so we're on page 11 of Mr. Shoup's direct testimony. Will you read line 13 through 18 for us?
Yes. As discussed by OG&E witness Sherman, Black Kettle was especially attractive because of its earlier availability when compared to some other new construction projects, aligning with the timing of our capacity needs in the summer of 2027. Also, the 20-year term for the capacity provides certainty for a longer period at known costs. In addition, this project is interconnected directly to OG&E transmission, providing firm transmission service from the SPP, which will be easier and less costly compared to other projects.
Okay, so in portion, yes or no, Mr. Shoup likes the certainty of the longer time period in this case.
I think that the testimony for Mr. Shoup identified the term of the Black Kettle contract with a low price as a certainty for customers. Yes.
So he likes the longer period? Is that a yes?
For Black Kettle, yes.
Okay. No further questions. Thank you.
Thank you. Mr. Layson, you have waived cross? Okay. Any redirect?
No, Your Honor.
Thank you. Any recross? Surely not.
Surely not. No, sir.
Thank you. Ms. Anderson, I'm going to go to you first, although you may not be quite ready.
My internet was not connected, but I think I'm good now, but not right now. Thank you, Chairman.
Thank you. Mr. Tate?
Sure. Thank you, Chairman.
Yes. Thank you.
All right, Ms. Riley. Mr. Shoup sent me to you to ask the RFP questions.
Of course.
So can you tell me how often OG&E issues RFPs?
It really depends on the need. I heard you earlier ask Mr. Shoup about, how many we've done in the last few years, so I made some quick notes. Since 2018, we've issued 7 RFPs, some of them for short-term and some of them for long-term.
And have those all been all source?
No, they have not. A few of those, 2 of those were bridge capacity RFPs, so they were directly targeted at short-term needs, which really can only be served by resources that are already in service or that are planned to be in service in the very, very near future. 2 of those were also solar-only RFPs.
So that's since 2018.
That's correct.
How many of those RFPs did OG&E self-bid?
2,
2 of those?
yes.
And in both of those, did OG&E select its own bid?
We did, yes,
Yes.
yes.
So going back further, how often has OG&E self-bid into its RFP?
I've been in this role since 2013, and so I don't really have any experience prior to that or expertise in how that was conducted prior to that tenure. My first experience with an all-source RFP at OG&E was in 2018.
So you're not aware if they self-bid between 2013 and 2018?
They did not.
They did not.
They
Okay.
did not.
I understand. So your experience only goes back to 2013, but are you aware of an instance where OG&E bid into its own RFP and did not win?
Well, in this RFP, actually, OG&E submitted 2 self-bids, and only one of them was selected.
I don't know if this will go into HSPI, but what was the other bid?
We may have to.
Is it?
Yeah,
Okay.
yes, that's sensitive.
All right, we can hold that for a minute then. What did the RFP specifically target, or was it just capacity? The all-source RFP.
Yeah, the purpose of the all-source RFP was to secure generation capacity. Our needs were shown, our capacity needs were shown in the 2025 IRP, in the 24 IRP, then we did the 24 RFPs, and then we did a subsequent 25 IRP. So those capacity needs that are listed there, that's really the purpose of the RFP, is to satisfy those capacity needs. So a resource that can provide both capacity and energy could bid into that, or a resource like in the case of the CPAs, just the capacity project, either one.
Mr. Shoup identified that there were some other objectives identified in the IRP. How, if at all, were those objectives included in the RFP? I think one of them specifically was dispatchability.
Yeah, so dispatchability is certainly an objective of the IRP, and I'm going to apologize if I get into a little bit too wonky IRP land, but in the IRP, the purpose of that is that the 24 IRP provided a preferred plan, right? And the objectives stated in that IRP really get to OG&E's ideal portfolio, addresses reliability, fuel diversity, things that help support the grid and our customers specifically when necessary, when needed. So the objectives of the IRP really address the portfolio of where OG&E wants to be. So when we got to the RFP, we were in a situation with capacity needs where we were selecting a portfolio. And so those are our objectives. And so we had applied those to the portfolio approach in the RFP.
Do you typically use a portfolio approach?
Only when the capacity needs are at a level where it dictates that and requires that, yes.
So I forget if it was Mr. Norwood or Mr. Bauer, but one of the witnesses suggested either using a separate method or maybe contracting with an individual to take a kind of broader look at prioritizing based on that portfolio need. Is that something OG&E has done in the past?
So in the IRP, we did contract with a consulting firm that used a portfolio optimization tool. Is that
Yes.
what you're referring to? Yeah. So the portfolio optimization software was used in the IRP certainly to select that portfolio. In the RFP, it wasn't a functionality that we had readily available to us, but the Oklahoma Commission has made a strong recommendation to us to go back and assess whether that would be beneficial.
So I'm not as familiar with that. I'm taking based on your comments that what you can, using that optimization for an IRP, you can't just take that and then apply it to selecting the resources that are responsive in the RFP.
So let me be clear. That functionality, the portfolio optimization software, it's a pretty complicated package of software and has some expense to it. In the 2024 IRP, since we had relied on the services of a consultant to help with that analysis in the IRP, that consultant had that software readily available to them, right? We just didn't have that lever in the RFP process.
Yeah, you didn't use that consultant as part of the
Correct.
RFP process.
That's right.
What is OG&E's current generation mix?
We are today 63% gas. I think it's 26% coal, 11% wind, and about 0.5% solar.
And how would these resources that have been identified through the RFP process change that mix?
I don't have those off the top of my head. Obviously, the gas is kind of a replacement swap out, if you will, because there's some retiring gas in our portfolio in the next few years. So it won't be terribly different, but it'll be a little bit different. The CPAs while they will be factored into our generation stack, it's a little bit different because we don't take any energy from those. It's just capacity.
Was dispatchability identified as a preferred attribute, if you will, in the RFP?
Not in the RFP, no.
What about time frame for availability other than immediate if possible? Was there any other time frames outlined in the RFP for when you needed resources or when you needed the capacity to be available?
So there was a requirement that the capacity had to be available before the summer of 2030. that was a kind of a threshold requirement. So any bids that didn't provide capacity prior to the summer of 2030 didn't clear the threshold, were non-conforming to the RFP. There were also some metrics put in place in the quantitative evaluation to score higher bids that had an earlier in-service date.
Scored higher if it had a sooner in-service date. Okay.
Correct.
Were there any back ends as far as not needing capacity beyond a certain year?
No.
The RFP lists a preference for resources within its territory.
Yes.
How does that preference play into the RFP process? Is that preference scored?
Yes. It's a qualitative score, so it gets an extra point, I think, subject to check, for resources that are located within the communities that OG&E serves.
Okay, that's a bit different than, so as I understand it, the RFP, if it's for an asset that's going to be purchased, it has to be in Oklahoma or Arkansas with a preference specifically OG&E's footprint. Is that preference to be within OG&E's footprint scored as part of the RFP? Meaning, if there's a resource that's in Oklahoma or Arkansas but not within OG&E's footprint, is it going to be reflected negatively in the RFP?
Let me read the language. It's been a minute. Are you, and just to be clear,
I'm looking at the chart on page 8 and 9 of your direct. I assume that's somewhat of a summary of the RFP.
yeah. Okay, so this chart, okay, so on the location, PSA here in description is purchase and sale agreement. So projects that were sold to or owned by OG&E, that's a requirement that they would be located within Oklahoma or Arkansas with a preference for OG&E service territory. CPA projects or PPA projects had other availability. And the reason for ownership, close to our operating system is just it's strictly operational, right? Because OG&E members are located in those locations.
So in relation to those PSA projects, that preference to be within the footprint, how is that preference reflected in the RFP? Is that a qualitative item like you
It
discussed?
is a qualitative score.
So
yes.
something within Oklahoma or Arkansas, but not within OG&E's footprint would get,
Slightly less,
okay.
slightly fewer points, yeah.
Is there anything in the RFP that specifically considered benefits to Arkansas ratepayers specifically?
Not outside of benefits to Oklahoma and Arkansas customers, correct?
But
That's
nothing
right.
specific to Arkansas customers?
That's right.
So there's a requirement in Oklahoma that you guys use an independent evaluator as part of the RFP process?
In certain circumstances, and this applied in this case, yeah.
Is that circumstance when you self-bid?
That is one of the options, yes.
When else would you have to use an independent evaluator?
I think it's centers around the materiality of the cost or a self bid, and both of those would have been true in this case.
Oh, so if it goes above a certain amount,
It
cost-wise?
doesn't specify the amount; it just says that it's material.
material.
Yeah.
And how is the cost associated with the independent evaluator recovered?
So those costs are those invoices come through the RFP process, and so they're recovered kind of with the projects that added to the projects.
Okay. Okay. So it would be spread across all of OG&E's ratepayers.
Yes.
Okay. Does OG&E ever receive unsolicited offers for projects outside of the RFP process?
Yes.
Were there any of those in this instance?
Those unsolicited offers come in, randomly through time. Generally, because, we are unable to share timing and details of, when the RFPs are going to be issued. Obviously, my team works very hard and knows kind of what those timelines are. So our responses to those folks, generally, if they're close to an RFP, we'll just say, you're going to have to bid into an upcoming RFP. And so, no, if there are any that bid into the RFP that we may have had contact with, I'm probably not remembering the specific details, but generally we funnel all those through the RFPs.
I would assume a similar response if you receive an unsolicited offer while you have an ongoing RFP would be to push them through the RFP.
Yes, as long as the window for bidding is still open, yes.
And assuming whatever the unsolicited offer is for meets what you're
Right.
soliciting in the RFP.
Right, it would be evaluated just the same as any other RFP bid, including whether it clears those threshold requirements.
Chairman, if you or Commissioner Anderson has any non-HSPI questions, I think now would be appropriate because I do have a couple questions that we'll probably need to go in camera for.
Thank you. Commissioner Anderson,
Commissioner Tate, he asked my question I was going to ask, so I'm good.
I have a few questions for you. If you can't answer these, please let me know.
Of course, Jim.
I'm intrigued by RFPs, okay?
Mhm.
I think they are very good in government, okay? Matter of fact, if a commission can have a humanistic view, we love RFPs, okay? You have a limitation on your RFP that it should be in your service area, correct?
For own,
The facility should be in your service area.
no, there's not a limitation on our service area. There's a preference for service area.
And how's that preference expressed?
As I discussed with Commissioner Tate, it is a very small point differential that those projects in our service territory would get assigned.
Okay. For the record, we need to be clear, though. Your service area in Arkansas is a narrow band across Fort Smith
Mhm.
and into, I believe, Johnson County, Arkansas. That's it. It's not the state of Arkansas. It's a very narrow band for your service area.
It's a small footprint, yes.
And that's about 8% of your customer load, okay? Now, I'm not sure if you're the right person to answer this, and you'll tell me if you're not. Will all of these projects be constructed concurrently? Or pretty close to concurrent?
The three projects subject of this case?
Yes.
Yes, generally they will be constructed concurrently. The exception, the Kaimichi project that we've discussed, is an existing project, so no construction.
And these are on Horseshoe Lake?
Yes,
And Horseshoe Lake is northeast of Oklahoma City,
yes.
correct? About how many miles from Oklahoma City?
Oh, gosh,
Where the projects will be?
yeah, I want to say 10 or 15.
10 or 15 miles?
Yeah, yes, Mr. Sherman or Mr. Lilac probably knows that much better than I do.
And do you know how many people will be employed to construct these projects?
I don't know, Mr. Lilac would be able to answer that
Who
question.
will?
Chris Lilac?
Oh, good. I love to have that name. Okay. He'll be. I see him in the back. He'll be glad to get that. But they will be constructed generally simultaneously or concurrently. They're about 10 to 15 miles from northeast of Oklahoma City, correct?
I'm sorry, Chairman, we're talking about Horseshoe Lake 13 and 14, is those?
Yes.
Yes, that's
Okay.
correct.
Okay. I have no further questions.
I have one more question before we go in camera. I don't recall which OG&E witness it was. It may have been Mr. Shoup in his filed testimony indicated, well, I hesitate to say a preference, but indicated that the resources picked through the RFP process would provide a benefit through a diversity of resources, or adding diversity to the resource mix for OG&E. Does that sound
Sounds
accurate?
familiar.
Okay. Does OG&E have a preference for diversifying its resource mix?
We state that preference in our IRPs, yes.
And was that preference stated in your RFP?
It was not stated in the RFP, but the selection criteria were clearly outlined in the RFP, and the IRP demonstrates that preference, yes.
So, of the projects selected, how does this help diversify OG&E's portfolio? You've selected a battery, which I understand is the first one within OG&E's portfolio. Is that correct?
Yes, it would be the first one.
But the other projects selected, the CPAs and the CTs, are gas projects, correct?
Correct.
Which is what a majority of OG&E's current portfolio is.
Yes. Yes.
So what am I missing? How does that help with the diversity?
So the selections if you take a step back and look at all of the projects that were selected coming out of the RFP, OG&E selected 7 projects in total coming out of the RFP. What you're seeing here today is 3 of those projects presented. So of those, 7 selections, 3 were solar, a couple were gas. So there was more diversity in the selection criteria. The contracting is a little bit more complicated process, and so what we are bringing you is 3 today, the ones that we have finalized contracts on, but the selections themselves represented a fairly high amount of solar as well.
So what I'm hearing is you're going to be bringing us more projects in the future.
I certainly hope so.
I think now is when we need to go in camera to talk about HSPI.
I mean, she always says something that sparks a question in me, okay? Let me see if I can grab it again, okay? I know the answer, but I'm going to ask the question.
Yes, sir.
Did you receive any proposals in Arkansas outside of your service area?
No, we did not.
Did you solicit any outside of your service area?
Well, the RFP was a solicitation, and it was open to all comers.
But it gives a preference to your service area.
Yes, it does.
If I were to read it, I would say that it's preferenced for the service area.
It is preference for the service area because that's where our customers are,
I
right?
understand.
In our communities.
Okay. Let's go in Cameron, and if you've not signed an affidavit, please step out and He's,
I'm slow. Remember, I'm slow.
okay. I think an hour will be enough. Thank you. We'll be in recess till 1 o'clock. Thank you. we're back on the record. Did you have a good lunch?
Good.
Is an hour enough for you, or do you
It
usually?
was
Okay.
very sufficient, thank you.
You know, us or more mature people like to have a nice leisurely lunch.
We
Okay?
know your track record on that.
That's thank you. There'll always be work, but there's only a certain time that there could be lunch.
There is, that's
Okay?
true.
So, Mr. Dennis, you want to call your next witness?
Yes, Your Honor, thank you.
Say his last name again. Sherman, okay. He didn't burn Georgia, did you? No, I'm just kidding.
Matt Sherman. I work for Oklahoma Gas and Electric. I'm the Vice President of Power Supply Operations, and our address is 321 North Harvey in Oklahoma City, Oklahoma.
You're the same Matt Sherman who submitted direct testimony in this docket July 25th, rebuttal testimony October 22nd. Now, rather do your rebuttal on October 3rd.
That's correct. I do not.
Thank you. Mr. Lewis, you wish to cross?
Yes, sir. Good afternoon. Yes, I was.
Okay, there was a number of questions to Ms. Riley about preference for project. First, describe what is OG&E service? Broad question.
Yeah, we don't have a diagram to show you, but essentially, geographically, it's central Oklahoma down the I-40 corridor, inclusive of Fort Smith area. North a certain ways, south a certain ways, but it essentially covers a lot of I-35 and I-40 through Oklahoma. Does that answer what you were asking?
Yes, y'all, and did I hear her right? Y'all don't have any service territory in New Mexico, is that right?
That's correct.
Okay. One of the bids is for a HL 13 and 14s, self-build in Oklahoma, correct?
Correct.
Have y'all had any self-build projects in the past that were built in Oklahoma?
We have.
Okay. Are there any that are outside of Oklahoma?
No self-build.
Mr. Sherman, answer to us. Focus.
Yeah, thank you for that
Yes,
reminder.
thank you. See, in Arkansas, we believe in batteries. For microphones. Yeah. Sorry. He's got you.
Okay, thank you. My question before we got our microphone updated was, do y'all own any generation facilities outside of Oklahoma?
There's one generation facility, although it's on the distribution system, that is in Arkansas. It's a small solar facility.
Okay, and where's that at exactly?
It's in the Fort Smith area, but I don't know exactly where.
Okay, but part of the OG&E service territory?
That's my understanding.
Okay, and one of the parameters for the RFP was they would like it to be an OG&E service territory, correct?
There was a preference for that, correct?
Okay. Has anyone for the company ever expressed a preference for the bids to be in Oklahoma themselves?
Who is anyone? I'm sorry.
Good question. Anyone from OG&E that you're aware of?
And then will you ask the question again?
Yes.
please?
Has anyone from OG&E ever expressed a preference for projects in Oklahoma?
Not explicitly, but I think Witness Riley covered some of the benefits of having, generation close to our load, which then is why we're saying in proximity or in our service territory.
Okay, but nothing explicitly saying we would like it to be in Oklahoma. We would like the project to be in Oklahoma.
Not that I'm aware of.
Okay. I'll pass the witness.
Mr. Lason, you waive, of course. Mr. Dennis, any redirect?
No redirect, Your Honor.
Commissioner Anderson? No. Commissioner Tate?
I don't have anything. Oh,
You have
sorry.
any questions?
No, I didn't have any questions.
No questions, okay. You may stand down.
Thank you.
Thank you. Mr. Chisenhall, call your next witness. Mr. Lulak.
Would you state your name, position, and business address for the record, please, sir?
Chris Lelak, Director of Major Projects. I work for OG&E, and my address is 321 North Harvey, Oklahoma City, Oklahoma.
Are you the same Christopher B. Lelak who submitted direct testimony and exhibits in this docket on July the 25th, 2025? Rebuttal testimony and exhibits on October 22nd, 2025, and sir, rebuttal testimony on November the 17th, 2025.
Yes, I am.
Do you have any changes or corrections to your testimony?
No, I do not.
Mr. Lelak, I would remind you before the chairman does to answer to them up there. And with that, I tender the witness.
Thank you, sir. Mr. Lewis? And you may want to get a little closer to the mic or just pull it up closer to you, okay? Thank you.
Good afternoon, Mr. Lelak.
Good afternoon.
What is your position with OG&E?
I'm Director of Major Projects.
Okay, and briefly describe for us what that is and kind of what your role is.
So in that role, I construct new power generation projects, transmission projects, and substation projects across the service territory. And in the case of Horseshoe Lake 13 and 14, I led the self-bid effort for the company.
How long have you been in that position?
Since 2019.
2019. Can you please turn to Exhibit CBL to your rebuttal testimony? And this will be a number of highly sensitive questions I think we will need to clear the room for.
Let's go into, in Cameron. If you are not signed an affidavit, please step out. I think we have one guest now.
Do we?
Okay, you may proceed.
All right. At one point in the various rounds of testimony, Mr. Bauer recommended an independent monitor to oversee, I think, the construction of the Horseshoe Lake facilities. Do you recall that?
Yes, sir.
Do you recall what your testimony was on that item or on that issue?
Yeah, I think I thanked him for the recommendation. And I said if Arkansas wants that, it would be reasonable for Arkansas to bear that cost. However, I offered an alternative that we could give you reporting on some frequency instead of having an independent monitor.
Well, so I wanted to ask about your suggestion that Arkansas customers specifically have to bear the cost of an independent monitor. As we discussed earlier, the independent monitor for the RFP is passed on to all customers, correct?
That's correct.
And that was done because specifically Oklahoma requires it, right?
Yes.
So Arkansas customers are paying for an Oklahoma requirement.
Yes.
But it's your testimony that if Arkansas has a similar requirement for an independent monitor on the construction, that Oklahoma customers shouldn't have to pay for that.
Yes.
So explain why in one instance Arkansas customers should be on the hook and on the other Oklahoma shouldn't be.
Well, I think there's ways to solve it that don't include cost for any customers. We write reports, internal reports every month, and those reports are transparent, and we're willing to share them at any point in time. So if there's a belief by this commission that we need an independent monitor, I guess I would defer to others on how those costs get spread out.
I appreciate that. In your testimony, though, you didn't defer. You made a statement, which I think the basis for it makes some sense. You don't want customers from one state subsidizing requirements put on, by another state's commission. But I think if we're going to be fair, since Arkansas customers are bearing the burden of an independent monitor for the RFP put on it by the Oklahoma Commission, that Oklahoma customers can bear the burden of an independent monitor if this commission requires that for the construction of Horseshoe Lake. Would you agree?
My testimony says otherwise, sir.
And you stand by your testimony?
Yeah.
All right. The OG&E recently had an application for Oklahoma, which we've discussed with previous witnesses. As part of that application, OG&E requested construction work in progress. Is that correct?
Yes.
And Oklahoma denied that. Is that right?
Yes.
Do you also think it's fair for Arkansas customers to pay for construction work in progress while Oklahoma customers do not?
That's not a topic that I typically deal in. I'm the construction witness and cost witness here, so CWIP is outside my realm of expertise, sir.
But you did testify to what you think is fair as far as when one customer base should pay for what is required for another customer base.
Yeah, and that was germane to my area of expertise, which is the reporting on the project.
I think that's all I have. Thank you, Chairman.
Thank you. I have a few questions for you.
Yes, sir.
Do I understand that these two projects, 13 and 14, are both self-billed?
They're self-billed in the sense that they're bids that were put together by OG&E. However, as you asked earlier, we contract these jobs out to be built by other companies.
But were these run through the RFP?
Yes, sir.
So these projects will be the low bidder from the RFP, right?
Yes, sir.
And you're an employee of OG&E. Will you be the construction supervisor on the projects, or tell me how that works?
Right. So I have project managers that work for me. So the ultimate accountability for delivery of the project is mine.
Okay. And do you subcontract it? Do you have different subcontractors doing different things on the projects?
Yeah. So the contract structure in the testimony is that OG&E purchases the turbines from GE, and then we hire an EPC contractor that assembles the site, assembles the turbines, and then buys some other balance of plant equipment and puts it all together for us.
And are you responsible for hiring any of the employees? Or is that all subcontractors responsible?
So the direct men and women that build the plant are hired by the EPC contractor. I hire some construction oversight that assures that they deliver what their contract says they should.
I'm not familiar with the subcontractors. Where's the home of those contractors? Or do they regularly do business in Oklahoma?
Yeah, I would say so. I mean, GE does work in Oklahoma, and then our joint venture partners, the primary construction partner is TIC, which is based in Kansas City. However, they hire traveling employees to staff the job. They bring some staff from their home office, but there are a number of traveling employees that build the plant.
Have you used these subcontractors in other projects for OG&E?
Yeah, GE does other work for us, sir, across many of our power plants, and then TIC is the subcontractor building Horseshoe Lake 11 and 12 right now.
Give me an idea of how many employees will be working on 13 and 14.
So the peak manpower of men and women on their tools is about 200. And then there's another 50 staff and indirect supervision that are on the site, so 250 total.
Would I understand this to believe that 13 or 14 is started first, and then people with craft do their craft there, and then they move to 14, so you continually having work occurring at both locations? Would that be fair?
Yeah, that's a good assumption. It's not a very drawn out process. We try to, because you have different crafts. You have like people that do concrete work, then equipment assembly, and we try to keep that as efficient as possible. So when they do one evolution on 13, they move straight to 14 and do the same evolution, and then they demobilize if they're no longer needed.
And this construction is about 15 to 20 miles from Oklahoma City to the northeast?
Yes, sir.
How close is that to is that the Kansas border? The north border?
Several, 120, 130 miles away.
How many employees do you believe are residents of the state of Arkansas?
I don't have that information, sir.
You don't have any idea?
No, I don't.
But many of these employees come from the home base of the contractor, which is in Kansas?
Yes, sir.
And what about the 50 employees? Are they OG&E employees?
No, 40 of them or so are from the contractor, and I have about 10 people out there.
Okay. And those are Oklahoma residents, I assume?
Yeah, the ones that work for OG&E are. Some of them I hire as contractors that are not Oklahoma residents.
So you have no idea if there are any Arkansans participating in this construction project?
No, I have no direct knowledge, no.
Okay. Give me just a moment here. I'll pass the witness. Anything further, Mr. Tate? You may stand down.
Thank you.
Let's see here, Mr. Chisenhall. Oh,
Mr. Dennis.
okay. My notes are inaccurate. Yeah, I wouldn't accept being called Mr. Chisenhall either.
He's in the room, Your Honor. So I'll just let that sit there.
For the record, I like Mr. Chisenhall. Not fairly or unfairly. Just he's a good sport.
I'm surprised you didn't make that compliment HSPI.
Strike that from the record, as a matter of fact.
We're in the daylight, Your Honor.
You may proceed. Call your next witness.
OG&E calls Jeremy K. Schwartz. Please state your name, position, and business address for the record.
My name is Jeremy Schwartz. I'm the manager of sales support and marketing analytics for Oklahoma Gas and Electric, and my work address is 321 North Harvey in Oklahoma City.
And are you the same Jeremy K. Schwartz who submitted rebuttal testimony in this case on October 22nd?
Yes, I am.
Do you have any changes to your filed testimony?
No, I do not.
And I'll remind you to testify to the commission. I
Talk
tender
to
the
us. That's right. You pass the witness.
Yes, Your Honor.
Mr. Lewis?
No questions.
No questions? No questions? Questions from the commission? Yes. Commissioner Anderson?
Mr. Schwartz, I have a question about the large load tariff that you all were ordered to file in the November 13th order by the Oklahoma Commission. Are you the correct person to answer a question on or two on that?
If we stay high level, I could
Okay.
probably answer some,
Okay.
but if not,
All right.
we'll defer to Mr. Shoup.
When do you all plan to file that tariff that you were directed to file in that commission order?
I'd have to defer to Mr. Shoup
Okay.
on that one.
All right. Shoop, is that the one? He'll be back up in a little bit. Okay. I guess the rest of this would probably go to Mr. Shoop as well, so I'll just hold the question for now.
Okay. Mr. Tate?
Thank you, Chairman. Good afternoon.
Good afternoon.
I think I asked Mr. Shoup this question earlier. If I recall, he pointed in your direction, so. As far as load growth in the OG&E territory, how much, if any of that, are you seeing in the Arkansas footprint for OG&E?
So before I answer, I want to clarify there's kind of maybe a little bit of semantics going on. When we talk about the large load exceptions that are discussed in my testimony and just large or load growth in general, I do want to clarify we're seeing load growth in both jurisdictions. I don't have a percentage ready today to share that we're seeing, but we do see it in both jurisdictions. We're definitely proud stewards in both of our jurisdictions of trying to support economic development. And then when we go to the large load side, while it's definitely been stated that there aren't projects in our forecast today that are Arkansas projects, they're just Oklahoma for now. We do have interest in Arkansas projects that could reach that level of exceptions in our forecast, but they aren't to the stage of assurance where we feel comfortable putting them in the forecast at this time, but there's definitely interest there.
So the load growth you are seeing, at least for purposes of your forecast, is primarily residential, or a mix of everything that doesn't qualify as kind of that large load?
It would be a mix of everything. So really what we do on the large loads, and I don't want to say there's a hard, fast number, but for conversation's sake, let's say it's a new emerging technology that doesn't fit historical trends. So whenever you do your load forecast, it's not going to come out in any type of trend line that goes in. And it's, again, conversation's sake, let's say 10 megawatts or greater. So that's kind of a rule of thumb of where we would look at it for it to need to be externally accounted for outside of the forecast.
So I think it was stated before that part of the reason for the capacity additions is because of load growth, particularly large load, that has gotten to the point that you feel certain enough to put it in your forecast. Is that accurate?
I would agree in part that is the reason for the resource need.
But you're stating at this time, nothing in the Arkansas part of OG&E's footprint is contributing to that because it hasn't reached a stage that you feel certain enough to put it in a forecast.
I would agree to that only on the exception piece that's an external modification to the load forecast. We are seeing what I'll coin as base load growth, which is not your large load exceptions. We are seeing that growth in Arkansas, which is, of course, increasing our resource needs.
I think that's all I have, Chairman.
You may stand down.
Thank you.
Thank you. We need to call Mr. Shoup back. Would you like to do that now? Mr. Shoup? Get you a cup of water and come on up. Oh, you're not drinking anymore.
I'm fine. Thank you.
I'm kidding. Mr. Tate, you have questions? Or you want to go ahead? Commissioner Anderson.
Mr. Shoup, I'm going to follow along the line of the questioning I was about to discuss with, or have with Mr. Swartz. So, you are aware that you all were required to file a large load tariff in the November 13th order by the Oklahoma Commission, correct?
That's correct.
Okay. When do you plan on filing that?
Well,
I believe it was due in July,
It's
next
due
July?
before July. I think
Okay.
our hope is to file it earlier than that. Obviously, there's been a lot of discussion nationally on certain states are moving in this direction, and our goal is to have a tariff that protects our other existing customers by requiring things like long-term commitments by the customer, minimum demand and energy charges, collateral requirements, exit fees. So if they leave the system, then they have to make us whole for the costs. We're working through some of that, and it's a little tricky. And we're also in some negotiations with some rather large fish right now that we're going to be doing a special contract for. So I think the plan is we're going to try to grease the skids on some of these issues with this one large customer and use those lessons learned to develop a tariff. And so that's the idea. I think we're hoping to have that special contract in Oklahoma done pretty soon, and then we would be filing thereafter in Oklahoma for the large load tariff, but no later than July, which is the commitment we are going to have through the order that was approved on November 13th.
Okay, but likely sooner, you said.
Hopefully, yes.
And would that apply to your new application for Horseshoe Lake 13 and 14?
I'm sorry, I'm not sure I
Is
understand
it
the
related
question.
to your, you said you were going to refile for 13 and
Oh.
14, refile your application for 13
No,
and
that's
14?
that's something different.
Okay.
I think what you're referring to, and you had asked somebody earlier about a new law that was passed in Oklahoma that relates to just the recovery mechanism for how we get recovery of construction work in progress. That law is now in effect as of the end of August. And so, and to clarify, what that law does, it doesn't give a preference for natural gas, but it says that if you have a natural gas facility, that the commission has to have a speedier review process. Instead of 240 days, it's 180 days or 6 months. And then also there is a provision that allows for construction work in progress for those specific facilities. There is another law, and I think this was a question you asked earlier, about a preference for natural gas. There is a new law in Oklahoma that prefers natural gas generation for electric utilities. However, it also says that the company can also present evidence to the Corporation Commission in Oklahoma for another type of generation if it's reasonable and prudent. So there is that preference that's stated, but there is also a provision that allows the company to come in. That went into effect on July 1st of this year, and it wouldn't apply to Horseshoe Lake 13 and 14 since we selected those projects prior to the effective date of that law.
Okay. Does the company have any plans to file, once you do file, if you do file a large load tariff in Oklahoma, do you have any plans to file a copy of that in Arkansas?
I think so. I think that would be a good idea. We haven't, when we finalize our rate case plans, we could consider filing it in our rate case, or we could do it as a standalone case. We haven't made a decision, but I definitely want to try to figure out what our approach is and then bring it to you all as well.
Okay. All right. Thank you. That's all I have, Chairman.
Thank you. Mr. Tate?
Thank you, Chairman. Mr. Shoup, you testified, I think it was in your direct, and one of the previous witnesses, I think, pointed me back to you when I asked this earlier. It was stated that the Arkansas project that was responsive to the RFP was not a comparable project to Horseshoe Lake.
Yes.
Can you explain what you mean by they're not comparable?
Sure, and I misstated earlier when I was testifying. I think I said it was a solar plant. I was wrong. It was
Is that
a
where
battery
is that where
project.
the chairman got that?
Sorry, it's my fault. And I had filed testimony in docket number 24-102-U that talked about our interpretation of comparable projects. And when I testified, I was talking about, when I say comparable projects, I think that they have to have similar costs, dispatchability, accredited capacity, and in-service dates. And the project, as I understand it, the one that was in Arkansas, the battery project, it was 100 megawatts compared to 450 megawatts for Horseshoe Lake 13 and 14. It was it was ranked much lower because of costs. It had a different in-service date by a couple of years, and it wasn't the dispatchable type of generation for natural gas. So when I think of comparable, that's what I'm thinking about in terms of the difference between Horseshoe Lake and the project that was offered into the RFP.
So you guys design your RFPs based on the results of your IRP, or at least the forecasts that come out of your IRP, correct?
Yes, and I think witness Riley talked about how we have kind of the objectives and the goals of the IRP, but when we come to the RFP, we don't call balls and strikes on the front end. We will kind of want to open the door wide open to see what comes in, and then kind of match the things that we're seeing based on the qualitative and quantitative criteria of the RFP itself. But then we also consider the criteria and the objectives of the IRP, and we try to marry those things together.
Give me just a second, Chairman.
Sure. Take your time.
Mr. Shoup, can you tell me how the RFP was designed to give priority to investments in generation in Arkansas?
I'm not sure we tried to give a preference. We wanted generation in Oklahoma and Arkansas. We had a slight preference for generation, at least PSA projects that were in our service territory. And then, of course, we opened up for capacity purchase agreements and PPAs and in the SPP, which include other states around Oklahoma as well.
So in short, there wasn't a preference given, or there wasn't a priority given to generation projects in Arkansas.
Well, we talked earlier about how there is a code of conduct between the evaluation team and the bid team. If you're asking, like, did the evaluation team tell the bid team we want to see a bid in Arkansas? We don't do that. The bid team came up with their bids on their own, one at Horseshoe and one at McLean. We don't have any existing sites in Arkansas, so we didn't propose a plan to do that. It would involve some kind of greenfield development, which we don't have line of sight to, so we didn't put that together. But it was up to the market to determine whether there is an option for Arkansas of a comparable project, and one was not proposed in the RFP. And if it had been, it probably would have been more expensive given the cost savings associated with locating the facility at an existing site.
So the RFP was open-ended. It identified preferences by the company for footprint and states for, in other states outside the footprint for CPAs and PPAs. But again, the RFP was not designed to specifically elicit responses or to prioritize projects in Arkansas, right? Nor would it have been because it was designed before the act passed, correct?
Well, yes, that's true. But, you know, the only preference that we had in our RFP, my understanding was inside of our service territory, which would include Arkansas, the Arkansas portion. But we did solicit PSAs in Oklahoma and Arkansas in general.
And there was not a separate evaluation done for the benefits to Arkansas customers specifically of that battery project compared to Horseshoe Lake.
No. And that reminds me of another question that Chairman Webb asked earlier about if we have any resources that are dedicated to jurisdiction. I wanted to remind the chairman of that, by the way. But no, I don't think we didn't do any type of analysis that is specific to either Oklahoma or Arkansas. The analysis that we do is based on all of our customers, not one versus the other.
Now, for purposes of the rider eligibility, OG&E is not arguing that a facility couldn't be constructed in Arkansas, right?
No, not at all.
Only that a comparable facility was not available.
That's correct.
And for OG&E's purposes, comparable means similar megawatts, similar in its ability to dispatch.
Cost, in-service dates, things like that. And those, I did test in that other docket, I did provide answers to your all questions about some of these things related to the act. And I talk a lot about the way that the company sees the comparability and the specific requirements of the 1305H.
That's all I have, Chairman.
Commissioner Anderson, anything? I appreciate you remembering my questions.
Yeah, I've triggered my memory.
I'll give you a few more, okay?
Okay.
Why limit it to your service area when a facility or a contractor could give you CWIP to run the distribution lines into your area? Because you testified earlier, that's what the CWIP is used for. It's on a tariff, yeah.
Well, I think Witness Riley talked about how inside of our service territory is obviously where our customers are, but it's also where our employees are. And, you know, it probably is very difficult, for example, if we had a power plant on the eastern side of Arkansas or even in, you know, the panhandle of Oklahoma where we don't have employees, we don't have service centers, we don't have necessarily customers. It would probably be difficult for us to have operations in those areas that are away from our customers. And not to mention, it's probably not within the SPP or it's not within the area of where our transmission transmission lines are. So that's why we kind of limited it to our service territory.
I don't think that's a valid argument when you mention the transmission lines because that could be contributed to construct those transmission lines. And woe be it to create jobs in Arkansas, okay?
Yeah, that's true. I think there might be a difference though if it's in like the Midwest ISO. That might be more difficult. But yeah,
but
you're right.
Your zone, your service zone is very, very narrow in Arkansas. very narrow. And there could be great locations just outside of your service area that would be discounted because of the point difference.
And that's a great point. And in the future, maybe we, don't give a preference for precisely inside our service territory. Maybe we can get a little bit more creative and say,
Right.
the western
that
half of
just came to me,
Arkansas
and I
or
thought I
something
would
like
ask
that.
and bring that to your attention.
Yes,
because
no, I appreciate that.
there's some great areas in that part of the state that probably could use some employment even there. Okay? Past witness, anything? You may stand down. You're still subject to recall. You never know about us.
I'll be here.
Okay, thank you. Mr. Chisenhall, do you have anything else? Remember, the burden is upon you. Yes, please. Don't move for a directed verdict.
Mr. Shoup is subject to recall because I'm not exactly sure how you want to do the settlement testimony, but he's the settlement witness.
Why
I
don't
don't have any more questions for
why
anybody.
why don't we go ahead and have, we don't have any settlement-specific questions for him, okay? You want to bring him up and have him?
No,
Okay.
I like him just where he is.
You are smarter than the average bear, okay? Thank you, sir. You're a gentleman and a scholar. Thank you, thank you. Staff? I guess, no, AG, call your first witness.
We will call Mr. Scott Norwood. Can you please state your full name for the record?
Yes, Don Scott Norwood.
Okay, and where are you employed, Mr. Norwood?
I'm president of Norwood Energy Consulting. It's based out of Austin, Texas.
Okay. In your capacity for Norwood Energy Consulting, did you file direct testimony for the Attorney General's office, rebuttal testimony, and settlement testimony in this matter?
Yes, I did.
Is there anything in any of that testimony you would like to change?
No.
Okay. I will tender the witness.
Mr. Lewis? Not Mr. Lewis, got my names mixed up here. Yeah, Dennis.
Thank you, Your Honor.
Yes.
Good afternoon, Mr. Norwood.
Good afternoon.
I'm going to assume that you understand the questions that I ask you today unless you tell me that you don't understand them. Is
Okay.
that fair?
Great. That's fair.
You're here in your capacity as a regulatory consultant on behalf of the Arkansas Attorney General. Is that correct?
Yes.
And we'll get to this point more in a moment. But you also provide consulting services to other clients in jurisdictions outside of the state of Arkansas. Is that right?
Yes.
In the last 10 years, have you ever consulted for utilities, or have you always generally been on the other side of them?
Yeah, I typically have in my career consulted for utilities, primarily public and electric cooperative and municipal utilities. But in the last 10 years, my practice has been solely on behalf of consumers, industry, state organizations that represent consumers.
And your direct testimony states that you are the president of Norwood Energy Consulting, LLC. Is that correct?
That's correct.
How many employees does Norwood Energy Consulting have right now?
I'm a sole proprietor.
One employee.
Yes.
Before we move on to the specifics of this case, I just want to discuss a very similar case that our chairman mentioned earlier before the Oklahoma Corporation Commission.
Okay.
Is it true that you testified in that case
Yes.
regarding these same resources?
Yes.
Did you testify on behalf of the Oklahoma Attorney General in that case?
No.
On whose behalf did you testify, sir?
I testified on behalf of Oklahoma Industrial Energy Consumers.
So that's a large industrial intervener in the case.
Yes.
And isn't it true that in Oklahoma, the Oklahoma Attorney General joined that settlement agreement that supported the projects?
Yes.
So the Oklahoma staff and an intervener called the Petroleum Alliance of Oklahoma. They joined the settlement as well, correct?
I believe that's correct, yes.
But the OIEC, your client, did not support approval in Oklahoma. Is that correct?
That's correct.
Is it fair to say that you've made the same recommendations generally before this commission as that you made in Oklahoma, sir?
Yes, I think there were some separate issues like on the strategic rider. But for the most part, the scope of the cases was very similar.
And in that Oklahoma proceeding, the OCC did not adopt your recommendation to deny approval of Horseshoe Lake 13 and 14, did it?
No, it did not.
In fact, do you have a copy of that order?
I do.
Okay. On November 13th of this year, the Oklahoma Commission entered a final order granting pre-approval regarding the generation at issues in this case. Isn't that right?
I believe that's correct, yes.
You've read this order?
Parts of it.
Okay, well, we may come back to it later, but for now, let's move on to the specifics of this case. You agree in this case that OG&E has a need for capacity that it must address, right?
Yes.
Let's go look at page 6 of your direct testimony, to be exact.
Okay.
The middle of line 9, where it begins with,
Eyes out here.
yes, sir, take all the time you need. Thank you. Page 6, line 9, that the middle there that begins with the company's forecast. Will you read that sentence for me, please?
The company's forecasted capacity needs in 2028 and beyond appear to be sufficient to justify the 995 megawatts of capacity that would be provided by the proposed resources.
Okay, and so it's fair to say you generally agree that OG&E has demonstrated a capacity need for these resources.
Yes.
And if the commission were to elect to approve these projects, these projects would help meet that need, right?
Yes.
And there's nothing in your pre-filed testimony that explicitly disputes OG&E's peak demand forecast, is there?
Does not dispute. I think I do characterize it as being somewhat uncertain, but it doesn't dispute that.
And regardless of what you've said, though, in your pre-filed, we've got on page 3, numbered paragraph 1, under the heading uncontested issues in the joint issues list. In this case, it says, OG&E has demonstrated a need for HL 13 and 14, the Black Kettle CPA, and the Kiamichi CPA. Do you recall reading that in the joint issues list?
I don't recall that.
May I approach, Your Honor?
You may.
It's the joint issues list.
Okay.
What I just read earlier, is it accurate?
Yes.
Thank
Yes.
you, sir. Moving on, you recommended approval of Black Kettle, the Black Kettle CPA without conditions, correct?
Yes.
And it's true that you've recommended approval of the 5-year Kiamichi CPA to the extent that the longer-term option's no longer available?
That's correct.
Well, let's go back to the OCC's final order you've got right in front of you, sir. It's true that that commission saw fit to approve the 5-year CPA at page 17, paragraph 37.
Yes, it's subject to cost recovery as determined in this case. They did agree.
And it's also true that in that paragraph just above there, paragraph 36, the OCC recognized that the IE did not raise concerns with the selection of the 5-year contract even though he was aware that the longer one was available, right?
It does say that, but I'm not sure I agree with that.
Thank you, Mr. Norwood. So let's shift now to the fairness of OG&E's selection process that you've testified about in this case.
Okay.
Specifically, the independent evaluator's findings and how those findings relate to your concerns, sir.
Okay.
It's your understanding, I hope, that the independent evaluator was authorized by an Oklahoma Commission order to monitor OG&E's RFP to ensure compliance with the applicable rules and provide a report, right?
I believe that's correct, yes.
And is it your understanding that that IE reported to the OCC staff and the Oklahoma AG?
I think that's right. I didn't see the details of that contract, but I think you're correct.
Thank you, sir. And you discussed the IE's conclusions generally on pages 17 and 18 of your direct testimony. You recall that?
Let me check here.
Yes, sir.
Yes.
You testified that the IE found that the RFP was run per the RFP rules and the Oklahoma Corporation Commission guidelines, right? At lines 5 and 6.
Yeah, this whole page is just stating what the IE's report stated. So I'm saying this is the IE's conclusions.
Okay.
These are the
Okay. Well,
IE's conclusions.
and I understand that. But, so you're saying you just recapitulated generally the findings from that report. Is that just a copy paste generally?
Yeah, I mean, I say the
Got
cue is please summarize the IE's conclusions, and so I summarized the IE's conclusions.
Okay. And
I'm not recommending or
I got it. I'm
Yeah,
just trying to figure out.
Yeah.
You created those bullets, or were they just pulled from the report?
those were the bullets in the report.
Mm-hmm. And do you agree with the IE that the scoring was reasonable in this case?
Generally, I think the ranking of the bids was reasonable.
And the IE didn't find that specifically that OG&E's selections were unreasonable, right?
Well, I would point you to the second to last bullet on page 17, where the IE states that the Horseshoe Lake facility may be reasonable in light of potential declines in capacity contributions for solar resources and OG&E's supply needs, but OG&E should provide more insight and analysis into this decision in order to provide assurances that this was not merely a case of the utility preferring an affiliate offer over a higher scoring third-party bid. So this was their conclusion,
Yeah.
and I thought that that was a little bit.
And I remember reading that in your testimony, and I'm so happy you brought that up.
Yeah,
Because
I
the
mean,
company, it did provide additional insights and analysis,
Well, these were final conclusions, so
and it did provide additional analysis
I'm sure.
into this case via its pre-filed testimony, right?
In this case,
Yes, sir. In this case, it provided additional insight and analysis.
yeah, but this is the IE's report.
I understand. But in your direct testimony, then you restated that and said the company should do that, right?
Should do.
Should provide additional analysis and insights into its decision.
That's the IE's conclusion.
I understand that, but in your own direct testimony,
I mean, the IE wasn't hired to come back and look at what you did after your choice.
yes, I understand.
You're saying based upon what the company did and what we reviewed and what we were able to determine, we still have some, it may be the best choice, but
Thank you.
there were some concerns.
But you read that report and you agreed and you testified in your written testimony that the company should provide additional insights and analysis. You said that as well, correct? Didn't you think the company should do that?
No, I took the IE's report and I cited that.
Okay. Let's go to page 18 of the OCC's final order. that I handed you, well, that you have a copy of.
Yes.
I see pink paper there.
Oh.
We need to go,
No, Your Honor.
okay.
This
very
is
good.
This is 18 of what now?
page 18 of the order, right
Oh,
there.
of the order, okay. Well, we're
Yes,
switching
sir.
between.
Yes, we
documents.
are now.
Okay,
Like I
I'll try to
said,
keep up with you.
page 18
Okay. Right.
of the OCC's final order.
All right? This is Oklahoma.
Yes, sir.
Okay,
Paragraph 42.
all right.
Will you please read that paragraph?
OG&E did provide additional information about why it selected HSL or Shoe Lake 13 and 14 in its direct testimony in this case. OG&E did not select one bid that scored higher than HSL 13 and 14 because of how it overlapped with and was duplicative with other projects that OG&E did not or did select. Further, of the 4 other projects that scored better than HSL 13 and 14, OG&E noted several reasonable issues that would favor HSL 13 and 14.
Thank you, Mr. Norwood. Let's now discuss your implication that it was possible that OG&E favored its affiliate bid and compare that to the evidence in the record. I believe on page 18,
Excuse me.
on your direct testimony,
Okay,
that's also right in front of you, sir.
all right.
You stated on page 18, line 18, that you had concerns regarding OG&E's selection of Horseshoe Lake 13 and 14. And then on page 8, lines 17 through 19, it seems to me that you implied that OG&E may have favored an affiliate bid. You remember that testimony, sir?
Tell me again where you're looking at on page 8.
Page 8, lines 17 through 19.
So you're saying, could you re-ask the question, please?
Yes, sir, of course.
Mhm.
Did any of your testimony in this case take the position that you thought it looked like OG&E favored its affiliate bid?
I don't know if I outright stated that, but, certainly taking the 26th ranked proposal over other lower cost proposals that were this was the company's valuation, were not only lower cost, but also had greater price certainty. So
Okay.
but they ranked that project as being last.
Mr. Norwood,
Okay.
I've got
I'm
to
just
ask.
I'm trying to answer your.
Well, I'm sorry. Your response has got me thinking of this question here. Did you review the code of conduct?
I'm going to object. He's got to be allowed to answer the
Well,
question.
State your,
He was answering the question and he kind of got cut off.
give him a moment to, just give him a moment to
Yes,
answer
Your
the
Honor.
question.
Yeah.
Mr. Norwood, was
Yeah.
something else
I guess
there?
what I'm saying is I don't think I really tried to accuse you of affiliate abuse, but what I'm saying is I agree with the IE that, you selected this project over a number of much lower cost bids, and this was based upon your own company's evaluation, and those bids, the bids for HSL 13 and 14, which is non-firm. I mean, it's going to, it's going to change. The company admits that. That bid was ranked by OG&E's bid evaluation team as having the highest price risk. So that they're saying, based upon our interpretation of what this offer is, there's uncertainty in the price. And so, I'm just observing those two things. And again, they're based upon your OG&E's bid team's evaluation. So I'm not trying to go out on a limb or anything. So I'm saying,
Okay.
I'm
Well,
saying, given that, there should be some questions there. And I don't think, you've proved those up.
Did you review, you finished?
Yes.
Did you review the code of conduct applicable to the company's all-source RFP in this case?
I'm not sure I did review that.
Wasn't it an exhibit to company witness Riley's testimony?
Yeah, I may have reviewed it, but again, I've reviewed a lot of documents in the case. I don't recall specifics of that.
It's true, though, that you don't dispute that OG&E established distinct bid and evaluation teams, correct?
I agree with that.
They publicly disclosed their membership
Yes,
and prohibited non-public communication between those teams, right, Mr. Norwood?
that could be, yes.
It could be. That's true, isn't it?
Well, I haven't invested that deeply, so I don't know what may have gone on, and you've got to draw the line somewhere in these cases as to how far you go on this stuff. All I can know is what the result is, and the result was based upon kind of the plain words of the company's own bid evaluation and the results, and then the IE's looking at it too independently and kind of concluding the same thing, that they couldn't figure out how this Horseshoe Lake project was selected, given the concerns over lower price bids.
Bottom line, you cannot point to any evidence in the record that OG&E's affiliate bid received special treatment or access to information not available to other bidders, can you?
I see that as kind of a secondary, beside the point issue to me. It's whatever happened.
You see that as a beside the point?
I don't think that issue has been explained.
It hasn't? Well, Mr. Norwood, when you were asked that same question in Oklahoma, you just said no. Do you remember that?
Which same question?
You can't point to any evidence in the record that OG&E's affiliate bid received special treatment.
No, and what I told you was I think that issue is kind of beside the point as to what I'm testifying to, which is given the company's own bid evaluation team results and what the IE said from an independent person kind of looking over their shoulder and trying to recreate what happened, his conclusions or her conclusions. I don't see that selection has been demonstrated to be prudent.
Mr. Norwood, do you remember testifying on October 13th, 2025 in the companion case in Oklahoma?
Yes, I do.
I'm going to hand you a copy of the official transcript.
Okay.
Page 240, line 14.
All right. Is this the full cross-examination and redirect, or is this just the cross-examination?
This is just one page of an excerpt of the transcript. It's the official transcript, as you see stamped on the bottom, and the court reporter's signature page at the end. Do you remember testifying on October 13th, 2025 in Oklahoma?
Yes. Well, I wasn't in Oklahoma.
You were under oath in an Oklahoma proceeding.
Yeah, I was physically located somewhere else.
You were under oath?
Yes.
Okay. Please read lines 10 through 14 of this official transcript.
Mr. Norwood, can you point to any evidence in the record that OG&E's affiliate bid received special treatment or access to information not available to other bidders?
Answer?
Or you can't. Can you? No.
Thank you, Mr. Norwood. Isn't it true you're the only witness in this case who recommends rejection of HL 13 and 14?
Yeah, the final positions, I guess, as reflected through the stipulation, is that what you're saying? That may be, yes.
It may be. You are the only witness that recommends rejection of 13 and 14 in this case, isn't that right? You've read the testimony, right?
Yes, I have. The reason I say that is I think Mr. Bowers, before the settlement, had basically said, if it was approved, it had to be approved with conditions. So
Thank you, Mr. Norwood.
I guess that's the
As
same.
we sit here today, are you the only witness who recommends rejection of Horseshoe Lake 13 and 14?
Yes, probably.
Thank you, Mr. Norwood. The same was true in Oklahoma?
I'm trying to think in Oklahoma what the AG and the staff did, but I think it was a similar situation where they both opposed it in direct testimony, and then there was a settlement which ultimately was rejected.
Counsel, same transcript. Page 241, lines 17 through 19. You were asked the same question. What was your answer?
Yeah, you're refreshing my memory on this.
I am.
My reading was the staff witness Purvis and AG witness Beeling both expressed some concerns, and as I recall, wanted to address those through certain conditions. So they didn't accept it as it was presented. They said if it was, my recollection, if it was approved, it needed to be approved with conditions, customer protection commission conditions.
Mr. Norwood, lines 17 through 19, sir.
Right?
Please look at those and tell me what it says.
Okay, so you're the only witness to this case that recommends rejection. Is that correct? And I said, I believe that's right. But
Thank
again,
you.
in terms
Thank
of
you.
outright rejection, as opposed to,
appreciate
yeah.
Yes,
Mm-hmm.
Have you read all the testimony filed in this case?
I've read all the testimony pertinent to areas that I was asked to look at, but not. I don't know that I've read every page of testimony.
So you've made recommendations in this case without reading all of the testimony.
I think I've looked at it, but I don't. As I sit here today, there's been a lot of testimony and several rounds of testimony filed.
I understand, Mr. Norwood. How about all the company's responses to staff's discovery responses, or discovery requests, excuse me, in this case?
I normally glance at discovery questions, but focus on discovery, that I filed, because those are things that I have questions on.
So you read the responses to the questions you propound, but not necessarily the responses to the questions that staff propounds. Is that
Right.
fair to say?
What I usually do is, because information's some of it's redundant, is I'll glance at questions, and if they're pertinent to issues that I'm still investigating, I will take a look at them.
Let's turn to your specific criticisms of Horseshoe Lake. Let's just look at page 8 of your direct testimony.
All right.
You testify that Horseshoe Lake was ranked as the 26th bid. That's just what it says, right?
Right.
And now I got to ask you, have you read the rebuttal testimony of Matthew J. Sherman in this case?
Yes.
Do you recall him talking about all the bids that were mutually exclusive projects? You remember that discussion, Mr.
Yes. I remember it.
It's also true that the Oklahoma Commission relied on similar testimony from Mr. Sherman in concluding that the selection of Horseshoe Lake 13 and 14 was reasonable. Do you remember that?
I don't remember.
Well, let's look at the order. It's right here, sir.
Okay.
Page 18,
Okay.
paragraphs 42 through 45 of this order right there, sir.
Okay. 40.
Well, that's page 18.
Okay. Oh, 42 and 45.
Yeah, well, It says OG&E did provide additional information about why it selected Horseshoe Lake 13 and 14 in its direct testimony in this case, right?
Yes.
Now let's move to your concerns about the cost generally on 13 and 14. In your sir rebuttal testimony, sir, your sir, rebuttal, page 6, line 10. Which, by the way, what was the date that sir rebuttal was filed? Do you remember?
I have November 10th.
Okay, that sounds right.
Okay, and
As an officer of the court, I will say that was the date.
page what now?
It's
Like a
page,
comedy
it's
routine here
page,
going through.
yeah, well, you had a lot of testimony, right? Yeah. No, I'm saying page 6, line 10.
Okay.
You say that the company has not fully explained why the cost of 13 and 14 is higher than 11 and 12, right?
That's correct. That's what I say.
I've got to ask, did you carefully read the direct testimony of OG&E witness Christopher Lilac in this case?
Yes, I did.
Do you agree with Mr. Lilac's representation that the power industry is experiencing a significant surge in construction to meet customer needs, sir?
Can you restate that, please?
Sure. Do you agree with Mr. Lilac's representation that the power industry is experiencing a surge in construction costs associated with meeting customer needs?
Yes, I agree with that.
And it's true that you've testified before this commission several times in recent weeks in cases of other utilities concerning new generation resources, right?
Yes.
And in a related hearing before the Oklahoma Commission, where you were under oath just like you are now, you acknowledged that there have been significant increases to engineered equipment and switch gears, right?
I don't recall that specific testimony, but I think I've acknowledged in my direct testimony here that the increases that were incurred related to construction and equipment costs, were sort of consistent with what I'm seeing in the industry.
Okay. Thank you, Mr. Norton.
My primary concern was in the
Yeah.
owner's cost
Yeah.
contingency.
Okay. But going beyond the filed testimony in this case, in the hearing in Oklahoma, you acknowledged that GE had told OG&E that if the company ordered those same turbines today at 13 and 14, they would cost at least $60 million more. Do you remember that?
I don't remember that, but that I wouldn't doubt that.
Will you look at footnote 6 on page 12 of that OCC final order right there in front of you?
Okay. Page
Page 12, yes, sir.
footnote 6.
Yes, sir. Will you read that?
The record in this case indicates that OG&E knowingly filed a case before the effective date to secure combustion turbines from General Electric at the secured rates before expiring on November 15th, 2025. The record indicates that should those contracts be renegotiated to today's prices, the turbines would cost over an additional $60 million.
Have you ever personally negotiated contracts similar in size to HL 13 and 14?
No.
Let's move to Act 373. Specifically, the discussion in this case of 1305H, the applicability of the rider. I believe you've testified generally that HL 13 and 14 do not satisfy the commission, the requirements of 1305H, right?
That's my opinion. I'm not a lawyer, but that's my opinion. based upon plain reading of the
Thank
that
you,
act.
Mr. Norwood.
Mhm.
Were you finished? I'm sorry, sir.
That's just my opinion based upon the reading of the requirements as defined in the act.
Let's shifting back to the way you feel the company hasn't chinned the bar with respect to H2. Page 26, line 9, not lines 9 through 13 of your direct. It seems like you're arguing that because Entergy is constructing Lake Catherine and Jefferson Power Station plants in Arkansas, it means that OG&E could build HL 13 and 14 in Arkansas. Am I understanding your testimony correctly?
With regard to my opinion on the SI rider,
Yes, sir.
my opinion, as I just stated, it's on page 25, is that the criteria for eligibility for rider recovery is basically based upon whether a facility is not available or cannot be constructed in Arkansas, for one thing, and whether the utility demonstrates and the commission finds that a strategic investment in new electric generating facilities located outside of Arkansas provides greater benefits to the investor-owned electric utility or investor-owned natural gas utilities customers in Arkansas than a comparable facility, strategic facility located in Arkansas.
Mr. Norwood, page 26, lines 9 through 13.
Right.
My question was, it seems you're arguing that because Entergy is constructing Lake Catherine and Jefferson Power in Arkansas, it means that OG&E could build Horseshoe Lake 13 and 14 in Arkansas. Am I understanding that testimony correctly?
I'm saying the company has not demonstrated, and that I pointed out that other utilities have been able to build comparable CT facilities in Arkansas. And so going back to the requirement that a facility is not available or cannot be constructed in Arkansas, which is page 25, lines 14 and 15, that's the requirements. I think, not to mention the fact they haven't quantified the benefits to Arkansas or benefits to Oklahoma in order to determine if there are greater benefits to Oklahoma. They also haven't shown that you couldn't construct a CT in Arkansas, and that's as I read this plainly, that seems to be what that's saying. You have to prove.
Okay. Did you participate in the Lake Catherine and Jefferson Power Station cases? Did you testify in those cases, sir?
Yes, I did.
And in those two separate cases, addressing two separate plants, you did not recommend that the commission approve either of those projects, did you?
I did not.
So while you felt those projects were not worthy of commission approval, you've argued, at least by my reading, that they're good enough comparables to say that 13 and 14 could have been constructed in Arkansas. Is that right?
Yeah, I'm saying this second half of the requirement 2 on page 25, again, line 14, 15 says, this is what you have to demonstrate, that a comparable investment is not available or cannot be constructed in Arkansas. And that's how I read that. Maybe that's not the proper legal interpretation.
Thank you, Mr. Norwood.
I don't think you can really say you can't construct a gas-fired CT in Arkansas.
Let's move to your discussion on why the company doesn't satisfy 1305H1.
Okay.
And I guess the best testimony for this may be your opposition to settlement testimony. Do you have that in front of you? Opposition to settlements?
Settlement testimony, yes. I have that.
Okay. pages 4 through 5.
Okay.
You've got the whole statute or that section quoted. And it allows for an out-of-state project to qualify for gouge or rider treatment if it provides in pertinent part greater benefits than a comparable strategic investment located in Arkansas. Do you see that?
Yes.
Would you agree that a large benefit of HL 13 and 14 consists of using OG&E's existing property and infrastructure at the existing plant?
You said 14 and 15?
13 and 14. Thank you, Mr. Norwood.
Thanks. Could you repeat that?
Sure. Would you agree that it's a large benefit of the 13 and 14 unit, this project, that it consists of using OG&E's existing property and infrastructure?
I don't know I don't have any quantification of that. So, and I think the company is responsible for demonstrating that, but I didn't see any calculation of, which is what this requirement is, that the benefits outside of Arkansas are greater than the benefits to Arkansas customers with it being located in Arkansas. And I think what I heard from Mr. Shoup say and Mr. Sherman is you didn't really look at it that way, and you didn't do that analysis, that you look at it as a system in terms of system benefits.
Mr. Norwood, thank you. But without seeing numbers on a page, would you just agree generally that it would save money to use a brownfield site as opposed to a greenfield site? All things equal.
Just that
Yes, sir.
issue? Okay. Normally it would, yes.
Thank you. Okay. Do you have any evidence to offer that OG&E could construct a facility similar to 13 and 14 in Arkansas at the same or a lower cost?
I don't know. That would depend on a lot of things. Where it's sited and what type of unit, and
Well, I won't press you on that.
yeah, that's the kind of thing that I think the company needs to
Okay.
evaluate to demonstrate this requirement.
Is it your position that a utility should not be permitted to undertake projects that were not bid into a competitive RFP?
Not necessarily.
Well, just last Monday before this commission, Commissioner Tate asked, what should the utility do if it gets an unsolicited offer? Your response was, tell me if you remember this, it should be required to go through the RFP process. Do you remember saying that?
Yeah, I think ideally what I talked about was there ought to be an ongoing RFP process so we don't get into situations where unsolicited projects come out of the blue and all of a sudden we get them at the commission and it's too late to do anything else. And so we're put in a situation where you got to select that project or the lights are going to go out, or you could wait to do an RFP, but that'll take another 18 months. And so that was the context of that testimony.
But you would agree that a facility comparable to Horseshoe Lake 13 and 14 was not bid into the 2024 all-source RFP at issue in this case, right?
Yeah, I don't know how you're defining comparable.
You heard how company witness Shoup defined it earlier? Did you hear that?
I generally recall that testimony.
Yeah.
Yeah, and I think
Just
I
like
think what
that.
he said
Just
is,
like that.
I think
That's how I define it.
Yeah, if you can, I didn't take notes on that, but if you
Sure.
could give it to me, I'd be happy.
To be comparable, generally, the company's position, as I understand it, is the units would need to have similar dispatchability characteristics, costs, in-service date, etc. You remember that?
Yes.
So with that definition, just for purposes of this discussion, would you agree that a facility comparable to to Horseshoe Lake 13 and 14 that was located in Arkansas was not bid until the 2024 all-source RFP at issue in this case.
Would I agree that?
Yeah.
One was not bid into the RFP?
Right, a comparable one.
Certainly not in terms of the site, the site as Horseshoe Lake is. But, I took a somewhat broader view than I think Mr. Shupin, that really what you're looking at is, they need capacity. And beyond that, you need to look at the overall benefit of the facility in terms of both energy and capacity and what your needs are on your system. And so, I guess I haven't seen that part of it, in terms of context of responding to these requirements for eligibility presented.
Have you read the settlement that staff and the non-unanimous settlement agreement that staff and the company have filed in this case?
Yes.
If we were to look at Section 1E of that non-unanimous settlement agreement.
I've got it here somewhere, but you've got me dancing around so much, I'm not sure where.
Bear with me, Mr. Norwood.
Oh.
You've got it?
I think I found it. Yep. Okay. Paragraph 1.
1E.
Okay. 1E?
Yes, sir. It says, consistent, generally with the position in Horseshoe Lake Units 11 and 12 in this case, staff has agreed with the company that Horseshoe Lake 13 and 14 are eligible.
I'm out. That's not showing up as my. Consistent with. Oh.
You know what, Mr. Norwood? Would you just read 1E for me?
Okay, well, it doesn't read like you were reading. Okay. E is Section 1305H compliance.
Yes, sir.
The settling parties agree that OG&E has satisfied the eligibility criteria provided in Arkansas Code Section 234-305H for HL 13 and 14, specifically a strategic investment comparable to HL 13 and 14 is not available or cannot be constructed in Arkansas, thus meeting the eligibility requirement set forth in Arkansas Code Section 234-1305H2.
And last question for me for now, while you've got that document in your hand. Can you read Section 1A?
A is prudence finding. The settling parties agree that OG&E's decision and the initial contract cost to construct the Horseshoe Lake Units 13 and 14 are reasonable, prudent, and in the public interest. The settling parties request that the commission issue an order finding OG&E's decision and the initial contract cost to construct HL and 13 and 14 to be reasonable, prudent, and in the public interest.
Thank you, Mr. Norwood. Pass the witness.
Nothing from staff.
Okay, going through my notes. Let's first talk about, you got a lot of questions about the Oklahoma order. Is it your understanding that a motion to reconsider has been filed regarding the Oklahoma order?
Yes.
Okay. I'm going to read you a portion of the motion to reconsider that was filed. I'm going to ask you some questions about it.
Okay.
Order number 753440 fails to address the evidence and arguments raised by OIEC and testimony and recommendations of the independent evaluator. The Commission's order is deficient and very one-sided, citing almost exclusively to the testimony of OG&E's witness giving the appearance as if the order was written by OG&E. The commission's findings revealed that the commission did not fully fulfill its duty to consider all the evidence presented. Do you agree that the order number 7534440, fails to address a number of the arguments put forth by OIEC?
Yes.
Okay, and this motion to reconsider was filed by OIEC and also by AARP, correct?
That's correct.
Okay. With this in mind, I want to discuss the order kind of generally. It's my understanding that the order, there was a dissenting opinion, a concurring opinion, and then I guess what I'll term as a final opinion, correct?
Yes.
In the Oklahoma Commission, it's consists of 3 members, right?
Yes.
So every single person had their own separate opinion on this case.
That's correct.
Let's briefly start with the dissenting opinion. Have you reviewed the dissenting opinion?
Yes, I have.
Okay, can you generally summarize what the dissent was?
Essentially,
I would just object and say this is beyond the scope of my cross. I didn't ask him any questions about the dissent. I just wanted to state that objection. Yeah. So.
Thank you, sir.
yeah, the dissent, I don't know if this is in the record or not, since it wasn't attached to the exhibit, the final order exhibit, but the dissent's pretty short and sweet, 2 pages, and it says, essentially the primary concern is approval of the project without a cost cap. And they're saying because the Horseshoe Lake project was ranked 26th out of the top bids, with both cost and risk considered and based on OG&E's own ranking. And that such selection would result in OG&E ratepayers paying 40% more for its selection than other available alternatives. And additionally, today's order authorizes pre-approval of contingency and owner cost of approximately $100 million that may or may not occur. And so he says, my proposed order would have excluded these costs, and then provides a laundry listing of other problems. Basically, he had with the, and this is Commissioner Hyatt, I don't know if you know him, but other concerns he had with the project and the terms of the final order.
Okay, and there was also a concurring opinion, which I think it used the term disagreement with the final order numerous times throughout the concurring opinion, correct?
Yes.
And what was the concurring opinion's main thesis, I guess?
Well, but basically and again, this is 2 pages were kind of attached to the order that were left off in the exhibit provided. And essentially what she says, this is Commissioner Kim David, is that while she supported many principles in the final order, she respectfully expressed her disagreement with the rejection of the non-unanimous joint stipulation settlement
Spin
agreement.
just a minute. I need to step out. For
Yes,
just a
sir.
moment, okay?
Would you like us to go on a brief recess?
Let's take a 10-minute recess.
Yes, sir.
these, you know, when your wife, this is a lesson for us all. When your wife is out of state and she calls, you go into recess, okay?
Yeah.
It doesn't matter what it is, you go into recess, okay? Thank y'all for
All right.
that. Mr. Lewis, you may proceed.
Okay, thank you. I believe we were talking about the various, I guess, orders that were put out by the commission regarding this. That we had the concurring, the dissenting, and the majority, which by majority was one person.
Right.
But you called it a concurrence, didn't you?
It is called a concurrence. That's the label of it. Yes, sir.
Okay.
Mr. Lewis, you're referring to the separate opinion filed by Chair David. Is that correct?
Yes.
It is?
Yeah.
I don't think that has been filed, and I'm not sure that was identified as a hearing exhibit.
Well, and to be honest, I thought when he identified it, he was identifying the entire, all of it, and then when he sent it over, he just had the majority. I would like to offer it up so that the commission could get the complete picture. I didn't realize what he meant was just.
Is there an objection to all of it being included? Because I understand you initially had just what we're calling, the controlling opinion, whatever we're going to call it. And then I think the dissent was sent over later, but I don't know that anybody has included the concurring opinion by the chair.
No, sir, I would move for admission of the concurring and the dissenting to offer the complete picture for the
Mr.
commission.
Dennis, you want to
Your
respond?
Honor, at the beginning of the hearing, Chairman Webb indicated that the commission had a copy of the final order. The commission certainly can take administrative notice of that order without us necessarily swelling the record with it. Alternatively, I would propose that the parties could submit the entire thing into the record if you would like.
Yeah, and I think I made it clear that we were aware of the order.
Thank you, Your Honor.
And I think that we should put the entire order in the record, okay? And the concurrence and dissent, so we have the full picture.
Okay, and just to clarify, because there's also a number of other documents, they basically summarize all the testimony too. It's a kind of a big package. Do you want everything that?
I don't know that we need that, Chair. I think it's just the three opinions, since those have been referenced primarily in this hearing.
And Your Honor, that went into the decision because there is a summary of all the testimony in the case in between the precedential portion of the order and the concurrence and the dissent. Sandwiched between those is a summary of all the testimony.
Let's go ahead and get it all.
Yes, Your Honor.
Let's just, that way if we need it, it will be there and we can refer to it, okay?
Okay.
Yes, Your Honor.
And I will after
But you may proceed.
Okay, and after my testimony, I will.
And so this is admitted into the record, okay?
Okay.
The full order and testimony of the Oklahoma Corporation Commission.
Okay. So we've talked about the dissent, the concurring, and so the final order, the majority that was issued by, and which was the commissioner who issued that?
The Ryan Bingman was the commissioner that drafted and issued the.
Okay. And do you have an opinion on the majority opinion is what I'll refer to it as?
Yeah, I think obviously I disagree with the HL 1, 13, and 14 determination, but as you read the specifics of it, the specific findings, and these are, on the first 25 pages or so of this huge order. They're really, in my mind, they're probably better than the non-unanimous stipulation that's been provided here. That they provide a number of protections without providing, a specific hard cap. For example, they provide for the cost recovery there to occur only after the plant goes in service, which may be, 3 or 4 years down the line, as opposed to here, you're going to have SI riders going to start passing through cost prior to, it's my understanding, prior to prudence review, which is not good with a return. And this commission, the Oklahoma Commission, denied any recovery of QUIP, so that won't be recovered in Oklahoma. They also designated a specific number as the cap above which the company, if you read this, is responsible for having to prove up when the project goes into rates. And in contrast, the stipulation here just says the contract price. I'm not even sure what that is, the initial contract price. And so you have all these, remember our criticisms on the cost of the project dealt with the company's overheads billed to the project, and then this contingency, this big, $43 million contingency, which is sort of a guess. We may spend that, we may not spend that, but this stipulation basically is deeming that to be part of the initial contract price that we deem prudent. And so I'm saying and then, I'm not sure what they're calling the contract, but if the contract is, as they've described it in the testimony, something that allows for price increases to occur, it doesn't disallow, for example, tariff effects, import tariff effects. It does not disallow cost increases due to project delays. And whereas it's being evaluated versus bids, much lower cost bids that have fixed pricing. And those guys can't come back in and say, we want some more money because something changed in our operations, our O&M costs went up, or we found out there was a change here that we need to flow through. That was set in stone on the negotiations. And here, the compromise is, and the settlement here is, we take this initial contract cost, whatever that is, and we're deeming prudent up front. And I don't think that's bad precedent. So there's some things in here, they also limit the period for which the rider, once it goes into effect, which again, after plant's put in service, to 18 months. So they've got to, if they want to recover that, if they're over-earning or whatever, if they want to recover that, they've got to come in and file a base rate case beyond that 18 months. So, this is not comparable. I guess what I'm trying to tell you is this is not comparable to what we have on the table as a proposal that's being addressed under the non-unanimous stipulation. And in some ways, I think it adds protections, customer protections, which I don't really see in the stipulation here.
Okay. And there was a question about you said that you were okay with the Black Kettle CPA. What's your basis for why you're okay with that?
Well, it was ranked number 3, and I'm not a big advocate generally of batteries. I've seen, I haven't seen one yet that made sense when you ran the economics on it. But this is a PPA and purchase power agreement, so it has fixed pricing in it. And there's, the company is on the hook for providing that capacity, and it was ranked 3rd on cost and risk and overall scoring. And so I see that's, might be a good way to try one as opposed to having a pilot, and it's a fixed cost, and up front it's cheaper than anything else you can buy or build.
And just for clarification, you actually, in a previous docket, said to the commission that you were okay with a combination solar and battery in Jefferson, but that was based off of the circumstances of that whole entire situation, correct?
Again, yeah.
Okay, I just wanted to make sure we clarified that for the record.
Yeah, that was particularly good. The storage, the solar part of it was real good, and the solar and storage together were pretty good. I thought, given the totality of that on Jefferson, it made sense.
Okay, And Black Kettle was also, what was the term of years for that?
20 years,
Okay, so it locked up some capacity for down the road,
yes.
and you thought that was beneficial?
Yes.
Okay. Why do you think that's beneficial?
Well, we're in a period of great uncertainty and rising costs now, and you know, normally I would say if you can lock in something that you don't have to build and that's not subject to ongoing cost increases that you didn't anticipate, you should do that. You know, you should take advantage of a long-term project with some certainty in the pricing.
Okay. Next, it was brought up that you were the only witness calling for rejection of HL 1314. Why are you calling for rejection of that?
Well, because there are no conditions on approval, but also, again, the primary concern is it ranked 26. I don't think it's any more difficult than that. And the company, has some obligation to demonstrate that there was a reason for that. And I haven't seen any strong reasons offered up. I know there's, an Oklahoma law that says, we want to favor building gas plants, and I understand that, but I think, obviously if the bid price had been better and they'd been able to explain the big contingency a little better, maybe I'd have and made the price certain. I think this is just like building any other power plant in my mind. It's if you're not going to hold them to that cost and you're allowing them to evaluate that project versus a fixed price contract, unless it's real close, and this is, they're twice as high as the fixed price contracts, there's some questions that should be raised, and I'm not in favor of approving that one, but, we approved HL 11 and 12. There were costs, and for that matter, ultimately approved the Air Force Base,
And is it your opinion
project.
that the 10-year Comici CPA could help provide that capacity as opposed, or it could have possibly help provide that capacity as opposed to HL 13 and 14?
Yeah, there were 10, this is kind of puzzling, there were 2 10-year agreements, and actually, if you look at Mr. Schumer's testimony, there was a table in there of bids they selected for negotiations, and the 10-year Kiamichi was the one he showed they selected for negotiations, and I don't know if that was a mistake or a typo or what, but I think it's sort of common sense. If you can get something that's half the cost, according to your evaluation, half the cost and less risky for 10 years, why would you not do that as opposed to a 5-year? And I know I probably said this before, but and then the other thing, the same owner, I can't, project developer, it's existing plant, just like Kiamichi, offered up a 10-year, 250 megawatt deal, and it was ranked top 5. And they've just, you could have done that, and so you could have locked up 700 megawatts for the next 10 years at a fixed price. It's half of what you say now you're going to pay for that plant, these CTs, which is not guaranteed. If we have import tariffs and that blows up, you've made a real questionable decision.
Yeah. And just to clarify, as I'm going down my list, there was a question about whether you had read all the testimony.
Yeah.
You have read every bit of testimony that pertains to the issues you were hired to look at, correct?
That's correct.
Okay. There was a number of questions about Act 373, and then it was brought up that you referenced JPS and Lake Catherine, but that you objected to those being built. You didn't object to. You objected because of the price, correct?
Yeah, the price and the fact that they weren't subject to bidding.
Okay.
But the price, for sure.
All right. And to your knowledge, has OG&E made any comparisons to any projects in Arkansas? Comparing HL 13 and 14?
I don't recall seeing that in the testimony.
Okay. I'll pass the witness.
Thank you. Recross. Normally, we don't allow that, but go forward.
I really appreciate it, Chairman. Just a couple of questions.
Okay.
My friend brought up the motion to reconsider in Oklahoma. Has that been granted?
It's my understanding, and it's no, but it's
Okay,
my
thank
understanding
you.
they've got 30 days to act on it.
You've testified in a lot of cases, right?
Yes,
You've read a lot of orders.
yes.
Do you understand that dissents are not precedential?
Yeah.
Thank you, Mr. Norwood. No further questions.
Thank you. Commissioner Commissioner Anderson,
Do I look like Commissioner Tate?
don't put me on the spot.
Nope.
I'm joking. We've been going for a while. Okay. Mr. Norwood, you and I have had several opportunities in the last few weeks to have a dialogue about independent evaluators, independent monitors.
Yeah.
We'll call them independent evaluators in this case because I believe that's how they're referenced in the testimony.
Yes.
What knowledge do you have about how Bates White was selected for this particular RFP?
I think Bates White, in terms of how the details of how they were selected, knowing that this was a state public service commission choice, there was a bidding process. But they've done now a number of these projects, so I think they sort of gained confidence, and they've got they may have a multi-year contract, but they're doing a lot, almost all the IE work for the Oklahoma Commission.
Okay, so they're doing this in many cases and have
Yes.
been for some time.
Yes.
Okay. In your opinion, we've also talked in various cases recently about our concerns about why we think an independent monitor or evaluator could be helpful in the RFP process, particularly when there are self-bids involved. Is it your opinion in this case? I'm trying to learn as much as I can about this process. So
Yeah.
is it your opinion in this case that the independent evaluator has helped accomplish some of the goals that we've discussed with an independent monitor and having them participate in the RFP process? Is this a good example of what that should look like?
Yeah, it was a pretty good report. I think in a prior hearing we talked about this, maybe Jefferson Power Station hearing, that to me it doesn't make sense to have this guy do all this work and to draw conclusions that are kind of leave you with questions. You know, either way, I think they should be forced to testify. I mean, you're paying them a bunch of money. And I don't think, in the grand scheme of things, the project is not a lot of money. But to pay them the extra amount of money to come defend their report and explain conclusions that are not clear in the report, I think is asking very little and would be very valuable. So I do think they add value, no question, but to have some independent assessment. But if you can't do discovery and ask them about the report, it's lesser of a value.
I understand what you're saying about the testimony. I agree that would be helpful if you have someone that has gone through the process
Right.
and developed an opinion and made recommendations. It is helpful to have that dialogue
Yeah.
with them too. I agree with you there. Outside of that, I think I am hearing you say, but you correct me if I'm wrong, that in this case, this is a good example of an IM participating in the RFP process and helping to yield the types of results that we're looking for. So
Right.
in that person's recommendations and so forth.
Right.
Okay.
And like Bates White, they're doing a big IE analysis, or have done one and presented a report in PSO's filing. And so now you have two utilities in the same area going out for assets. So that gives you sort of insight as to, you know, what other utilities we're getting from the market and you know, sort of in short order in the same time frame. So I think it's a real valuable thing that, and of course, they're doing work around the country. And so they're seeing all the best trends and best practices in bidding and bid evaluation. And like for example, these guys, Bates White, recommended both in this case and in the PSO case, this what you call portfolio optimization modeling at the end of the process to kind of reconfirm the decision making on selection of bids. That's a really good idea, and it probably doesn't cost that much if you're coordinating the bidding cycle with the IRP cycle, which makes sense. So when you're doing that work in the IRP, you've got bids that could then be plugged into that same model, and then during, you know, consistent with that same work, evaluate if we did these 10 bids, these were our 10 best proposals. If we evaluate what is the proper number of projects and what should we select, the way it's done now is so ad hoc. I mean, the company is just, you know, those bids are not necessarily even the best group of bids that should have been done. They basically just selected certain types of bids, including, of course, Horseshoe Lake. They wanted a generation project in with the other options. So why have a subjective selection of bids to negotiate as the finalist, rather than just have your own model evaluate those proposals and say, what is the best amount, what is the best mix of resources to solve our needs? And, you know, if you do that, these cases wouldn't be so controversial. You know, you'd have results that were much more defendable. And I think Mr. Bowers recommended that. I know the people in Oklahoma, the staff, and I think the Attorney General, they're all recommending this portfolio optimization model at the end. You know, at the end of the process, we narrowed it down to, say, 10 or 15 bids as opposed to, you know, your hand-picked bids.
Thank you. I agree there is some value in having an independent third party look at some of these things. And
Yeah.
so but I'd like to hear your feedback as to whether this is a good example of that feedback.
Yeah.
But I agree with you
Yeah.
on that it would be helpful to have that
Yeah.
person here to testify too.
Right, and
So-
that the provision on that got into the Oklahoma order, so that to the extent the order is adopted over there, it's going to be done, I think.
Thank you, Mr. Norwood. Chairman, that's all I have for now.
Mr. Tate?
Thank you, Chairman. Good afternoon, Mr. Norwood.
Good afternoon.
Mr. Norwood, you would agree that the company has identified a need, and that is why they're bringing us these projects to approve. Is that right?
Yes,
And that need is additional capacity.
yes.
Now, do these projects meet all of their need for capacity?
I think they're forecasting several hundred megawatts above that
So-
beyond 2030 because there were some bids that pulled out.
So you'd agree these do not meet all of their needs?
All their forecasted needs, that's correct.
Now, their forecasted need for additional capacity is primarily the result of forecasted large load in Oklahoma. Is that your understanding?
It's a big part of it. It's also dependent upon some retirements of existing units.
Now, that need they identified in their IRP drove them to issue an RFP for all sources, correct?
That's correct.
And they received quite a few responsive or conforming bids to that RFP, right?
That's correct.
Now, were you in the room for Mr. Shoup's testimony on comparable projects?
Yes.
Now, as I understood Mr. Shoup's testimony, he said projects are not comparable. Well, you have to look at a number of factors to determine whether a project is comparable. Price, location, in-service date, dispatchability. I'm sure we could probably sit here and think of some others that might, differentiate one project from another. Do you think when we look at whether a project is comparable, we should be looking at that in the context of whether a project meets the identified need for which the utility is acquiring the capacity or the generation in the first place?
To some extent, but if you do this optimization modeling I'm talking about, it'll tell you whether you should, despite the fact you only think you need 500 megawatts by this date, which is kind of how they did it. They did a little table and said, we need 500 this date, and this next year we need 600, and very specific numbers. With the optimization model, you could have got a bid, for example, these CPAs, that if you ran through the optimization model, it would select more than you think you need just because it's economic. It's worth doing.
Well, I think we're talking about two separate things. Both are important. But to clarify, the optimization model would help them pick the best optimized portfolio to meet their need, correct?
That's correct. But
For comparable projects, though, that applies specifically whether they can run a project through this new rider developed by the legislature.
Right. I just don't see that, other than broad terms of comparability, what that actually means.
Right. The more specific you get when you're trying to compare projects, the easier it is to say projects are not comparable, right? If you're talking it has to be the same size, different manufacturers make turbines in different sizes.
Yeah, it's not the way to do it.
Location are not the same, are often not the same. If you're talking about in-service date, projects responsive to this RFP had in-service dates spanning several years, correct?
That's correct.
And price is almost never the same, whether it varies a few dollars or it varies hundreds of dollars, or in terms of the entire project, hundreds of millions of dollars. The price can be very different, right?
That's correct.
So when you take all those factors into account, if you're looking at just Horseshoe Lake, there is not a single other project responsive to the RFP, much less projects in Arkansas that are comparable. Is that fair? There is not another project that is both a CT located at Horseshoe Lake with the same in-service date at the same cost.
Yeah,
Is that correct?
I think it's, I would view that, again, the comparable is not defined in the
Thank
rule.
you.
But I would view it more in terms of, do we need capacity or do we need baseload energy? And then, broadly, it could be that even if you only need capacity, you would get a great deal on, for example, a combined cycle unit, existing combined cycle unit, that when you modeled it, even though you didn't really need that energy, you can sell it into the market, and that's the best thing you should do. And so I wouldn't view that very narrowly, that I only need 400 megawatts. You need what's best for your system, once you get those bids.
So down that same line, Mr. Norwood, in fact, if you read it that narrowly, a project that might better meet your needs wouldn't actually be comparable to the selected project, meaning you actually need capacity sooner. The project selected, if you will.
Yes. Yes.
If you need capacity sooner rather than later, but the selected project provides capacity in a couple years, a project that would provide you capacity immediately wouldn't be comparable if you have such a narrow definition.
That's correct. You can shoot yourself in the foot by being too specific.
Is it your understanding that the utility didn't provide any comparison of benefits to Arkansas customers specifically for the selected projects versus any other projects that might be in Arkansas?
Yeah, that's stated in my testimony, I believe.
Did you have an opinion on the additional sum that is requested for the CPAs?
I didn't look at that issue directly in this case, but my opinion is that there should be no additional sums in Oklahoma that was not allowed, unless there's some regulation or some provision in Arkansas that says that's necessary or shall be given for these reasons, I would discourage that.
So there is a statute in Arkansas that allows it under certain conditions. But since you brought up the Oklahoma decision, it was requested, the company requested a return on the CPAs in Oklahoma, correct?
That's correct.
And the Oklahoma Corporation Commission denied that.
That's correct.
Were you in the hearing room when Ms. Riley testified or answered a few of my questions?
Yes.
Did it surprise you to hear that since she's been at the company, 2013, OG&E has self-bid into RFPs twice, and both times OG&E's projects were selected?
No, I'm not surprised by that.
I think that's all I have. Thank you, Chairman.
To follow, excuse me, to follow up on that, do you have a concern? I think Mr. Dennis was going here. Do you have a concern about the way they conducted their RFP and that the self-bid was awarded? You have a concern about that from an ethics point of view or from any point of view?
Well, really, in both sense, I didn't claim, there was, ethical violations or affiliate self-dealing, but certainly when an IE looks at it, and he's looked at a lot of these, and he says, well, it may be the best choice, but it's not clear to me how they got to that decision based upon what's been.
So you think an independent evaluator could help alleviate that concern if they oversaw the RFP methodology?
I think it would greatly help. They can ask any question and they can be involved in any part of the deal, except, this IE was asked not to be involved in the negotiations. And I think there needs to be some kind of closing of that loop.
You're aware of the location of these facilities.
Yes.
Are you aware of any jobs in Arkansas that are being created by this construction project?
I'm not aware. I'm assuming most of I'm assuming most of the jobs are going to be in Oklahoma at the plant.
I think that's all the questions I have. Do you have any further? Nothing, anything further, Mr. Tate? You may stand down.
All right. Thank you.
Mr. Layson, call your first witness.
Staff calls Jeffrey Bauer. May I proceed?
You may proceed.
Mr. Bauer, please state your name, your position, and your address for the record, business address.
Jeffrey Bauer, I'm a principal consultant with Daymark Energy Advisors, and my business address is 370 Main Street in Worcester, Massachusetts.
Are you the same Jeffrey Bauer who filed direct testimony and exhibits on September 24th and whose surrebuttal testimony exhibits were filed on November 11th of this year on behalf of staff?
I believe it's November 10th, but otherwise, yes.
And do you have any changes or corrections to your testimony today?
No, I don't.
I'll tender the witness.
Mr. Dennis? Any?
Your Honor, we've waived cross of staff witness.
Just wanted to hear you say that.
Yes, sir.
Yes, sir, Mr. Lewis. Well, you may proceed.
And I did have a point of clarification. You asked that the Oklahoma documents be admitted as an exhibit. I can hand that here, or I can have it filed. What is y'all's preference?
Is that everything that he had asked for? I know the chairman
Yes, it
specified
is.
he wanted
It
the
is all three of
summaries
the orders and the summary.
and the summary of
The
testimony.
summaries.
Okay.
I think we could just admit them here.
Okay, I will move to, if this is Attorney General's Exhibit 1.
They are, objection? Objection? No objection.
No objection.
They are, no objection, no. They are admitted. Save the clerk some work. Thank you, sir. She will.
Good afternoon, Mr. Bowers.
Good afternoon.
Okay, just a couple questions. On
Pull
your
that mic over in front of you. Okay, there you go.
There we go.
There you go.
In your SIR rebuttal, you discussed the CPAs, the Comici CPAs, specifically the 1-year CPA and the 5-year CPA. And you articulated somewhat of a concern that it added up to more than 5 years. Do you recall this? Specifically on page 12, lines 3 through 8.
Yes, I want to be a little careful because there is some HSBI
Okay, yeah, absolutely.
in that portion of my testimony.
So do you have, can you tell us about that concern?
The concern is essentially that if the company executes multiple contracts and the sum product of those contracts, particularly in this case where they were executed on the same day with the same counterparty, that if the total of those contracts exceeds 5 years, it may inadvertently or intentionally, and I'm not making any assessment there, avoid the requirement to get commission approval for a contract longer than 5 years.
Okay, and I think in here you say it would appear to set a bad precedent. Is that correct?
Yes, I say that here.
Okay, is this still a concern that you have?
It's still a concern in that if that issue is not fully resolved here, that issue could occur at another time in the future. In this particular case, given the arguments of the company and some issues discussed here regarding the fact that the two contracts were bid into separate RFPs, I'm not concerned here with that particular issue, but I don't think that the issue of whether that sets a precedent has been resolved.
Okay, thank you. In your SIR rebuttal, you also recommended an independent monitor. Is that correct?
For the HL 1314?
Yes.
Yes. I did.
And I know we've kind of talked about it, but in your opinion, what are the benefits of that?
The benefits really are to get some additional customer protection by having another independent look at certain non-fixed expenses. Specifically, I think I'd refer to the open book items as well as the use of contingency, allowing an independent monitor to review those and be able to validate to the commission that those expenses were needed and that there weren't other measures that could be taken to minimize customer costs.
Okay. And do you put any value in the fact that the monitor is independent? It is not one of the parties to this case. They are looking at it from a different viewpoint.
In general, I think the independence helps validate that customers' interests are protected.
Okay. Can you please turn to page 19 of your SIR rebuttal?
I'm there.
You're quick.
Got lucky.
Can you read line 17 through line 1 on the next page, or on page 20? Yep.
Yep. The final concern
Yes, sir.
The final concern I raised in my direct testimony is that under Arkansas Code 23-4-1303-10A, Romanet I and Romanet II, strategic investments are intended to support reliable electric service and economic growth in Arkansas and I noted that the company had not demonstrated that the project is needed to serve any economic growth opportunities in Arkansas.
Okay, and I believe there's been testimony that there's large load growth in Oklahoma. And are you saying that you're not sure there's any of that here in Arkansas?
That's part of it, yeah. My understanding is that the economic opportunities associated with large load growth are primarily in Oklahoma, and I think the company has testified today that while they support growth in Arkansas, they haven't seen that yet.
Okay. I'll pass the witness.
Thank you, Mr. Layson. Any redirect?
Just one. Mr. Bauer, Mr. Lewis pointed out your testimony regarding 23-4-1303-10, which is the definition of strategic investments under Act 373, correct?
Yes.
And your testimony and the question that you answered was regarding Romanet 1 and 2. One of those, your testimony that was read just a minute ago talks about how the company had not demonstrated the project is needed to serve any economic growth opportunities in Arkansas, correct?
Correct.
Another, I guess, Romanet 2 in that definition addresses reliability of electric service, right? Not just economic growth.
Yeah, I don't have it in front of me, but that's my recollection.
And so your testimony notes here, your concern is regarding the lack of demonstration that the project is needed to serve any economic growth opportunities in Arkansas, right?
Correct.
Okay, thank you.
Anything further?
No, sir.
Ms. Anderson, any questions?
No questions, thank you.
Mr. Tate, any questions?
Just a couple. Mr. Bauer, you've had an opportunity to review the RFP.
Yes.
Was the RFP designed to prioritize Arkansas generation?
I don't believe it was designed to prioritize it over generation in any other state.
In fact, it would actually penalize Arkansas generation in Arkansas if it's not located within OG&E's territory, correct?
There is one of the qualitative factors does prefer projects within OG&E service territory, yes.
And did the company perform any comparison of benefits to Arkansas customers for the projects they selected versus any responsive Arkansas projects?
No, I'm not aware of any specific analysis comparing those, no. Beyond just the general evaluation of all bids and the impacts to, all customers under the scoring.
Do you agree with Mr. Shoup's definition of what is a comparable project?
In general, I think that the factors that Mr. Shoup described are probably, in my view, more specific than needed for comparability. I think in the case, essentially because in the case of an RFP like this, it seems hard to believe that if you put out an RFP, you get bids in, and eligible bids are that two eligible bids within that RFP would not be considered comparable for the purposes of
rider eligibility.
Rider eligibility, yeah. I think that. I mean, I'm not. This is not a legal interpretation of the intent of the legislation and the definition of comparability under rider, but in terms of power supply planning principles, just if you're doing an RFP and there's eligible bids, they should be considered comparable.
How does the settlement agreement address your concerns about the 5-year, the request by OG&E for a declaratory order on whether their 5-year CPA requires our approval?
Well, a portion of that question may be better to Mr. Marchand, but I would say that my view of the 5-year Kiyomichi CPA is that regardless of whether commission approval is required, that through the evaluation of the RRP that it's a reasonable resource and should be approved if approval is needed. But it doesn't exactly address the more legal, technical legal issue around whether that approval is required.
Based on your responses to Cross, it sounds like you still share a concern about how that process could be manipulated to avoid review. Again, not suggesting that's what occurred here, but just the fact that if it's 5-year, anything less than 5 years, not requiring our approval, you could just structure contracts so that they're 5-year or less contracts. Do you still share that concern?
I think it's still a concern. I mean, it would potentially avoid commission review, and when the contract is first executed, I wouldn't say that it necessarily avoids commission review for cost recovery and other purposes. So I think a utility should be cautious to enter into 5 consecutive 4-year contracts of a term that, under terms that they think the commission's not going to approve of, and then go into for cost recovery and not get it. So I think that that's a theoretical possibility, and I think, but I think the commission has other tools at its disposal to rein in, unreasonable contracts. Yes.
Mr. Chisenhall, is the length of the other contract that is potentially causing issues with the 5-year CPA, is that HSPI? The one that was done under the bridge RFP?
It is, but it's been totally blown out of the water today, quite frankly.
The length of that has been? Okay. Well, I'll try to honor that. I think I can ask the question this way.
Add this?
Sure.
Term that we have talked about for both of those contracts have been in whole numbers, a 5-year, whatever year. That's not precisely accurate. They are shorter than that now. I don't know that totally changes the subject of what we're talking about.
Okay.
Because as Mr. Bauer said, if you do a series of 4-year contracts, you end up at the same place. But this is not a 5-year contract that we're actually talking about.
I understand.
And the other one is not
I understand.
a whole number.
But for purposes of adding them together, they would still raise the question of whether that would require.
Yes,
Okay.
yes, it would be beyond the 5 years of the statute.
Mr. Bauer, are you aware if the first CPA, the one that is shorter, expires before the longer CPA commences? Is there a gap between the two?
I'm not sure.
Would that change your evaluation?
It might capacity contracts are intended to provide capacity during the periods at which SPP cares, right? It's for the capacity to meet the resource adequacy requirements. So if there is a calendar gap between them, but not a gap in terms of capacity delivery periods, that there's a distinction there. If there's no gap between the capacity delivery periods, then my concern would still exist. If there's a calendar month capacity, but it's not a capacity delivery period month, then I wouldn't be concerned about that.
Okay. I think that's all I have. Thank you, Chairman.
Thank you. Mr. Bauer, you've sat through all the testimony today.
I
Heard
have.
a lot of facts come out. I'm going to give you an opportunity to determine that these facts do not fit under Act 373 for CWIP, knowing that Oklahoma has not allowed CWIP. Is it still your opinion that Arkansas ratepayers should pay CWIP, even though the residents and ratepayers of Oklahoma are not?
Well, I have not reviewed the full record in Oklahoma with that sort of disclaimer.
You've heard the testimony.
To start, I've
today.
heard the testimony today. I think that the eligibility of the project, I think that there is, I understand that the commission still has some outstanding questions on eligibility for the rider stemming from 24-102U, which I did not actively participate in, but have reviewed the responses to commission questions in that case. So I know that there's still outstanding questions for the commission to determine. I think that in terms of some of the stickier issues that we've talked about here in terms of comparability, whether a Arkansas resource is available or feasible, in my mind, I think that the existence of the RFP, which was a competitive RFP with a lot of bids were received by the company, and the bid, or I guess there were a couple of bids, but one bid that passed the threshold requirements that was located in Arkansas. I think my view stands that that resource, the existence of that resource, does not mean that the Horseshoe Lake, that there are comparable alternatives within Arkansas for Horseshoe Lake. The broader question, I know that there's been some discussion about whether a hypothetical project should be sort of scoped out in Arkansas and compared to Horseshoe Lake. I think that is a challenging proposition in the context of an RFP, because you've got a lot of bids, and it seems like just because this one is an OG&E bid that there's an implication that perhaps they should scope out an alternative in Arkansas. I think that's a possibility, but I'm just not sure what you would do with that information. You know, if you they then scope out a project which is either comparable, you know, or preferential, then what do you do? Because it didn't bid into the RFP, so you kind of have to select what you want, what's available. Then I guess the question would be, can the project be approved but not the rider, if a comparable project in Arkansas could have been completed? So I'm not sure I'm helping you at all here, but
Well, you're doing a good job of waffling, okay?
I think what I'm trying to say is,
Well, I could see separating the two.
Yeah.
Okay?
Right.
One from the project versus the rider.
Yeah.
Okay?
I think that based on the responses to the RFP, I don't necessarily see a path to saying that the rider should be denied because there was an alternative in Arkansas. Whether the commission wants to determine that additional analysis or additional sort of project scoping should be conducted in an application for a rider, I think that's a reasonable step. I hadn't contemplated that per se in my review here, because I know these rules are still
Let me quickly
getting...
ask you a question, because you're going to continue your dialogue. You're trying to filibuster me, okay? Are you aware of any jobs that are being created in the state of Arkansas?
I'm not.
Okay. I had another great question, and I can't recall it.
Have
have any questions? Anything further?
No questions, Chairman.
Yeah. Commissioner Tate.
The project at issue here is a project being built by OG&E, right?
Yes.
So they're choosing to build this at Horseshoe Lake,
Yes.
just as they could have chosen to build it in Arkansas.
Yes.
But there's no evaluation or nothing has been presented to us about them evaluating sites in Arkansas, the cost difference between what that would have looked like had they chosen to build these here rather than at Horseshoe Lake. There's been discussion about the benefits of them building this at Horseshoe Lake, but no evaluation or discussion about why this project couldn't have been built in Arkansas, right?
That's correct. Nothing's been provided in this record.
Thank you.
You may stand down.
Thank you.
Thank you. Mr. Layson, call your next witness.
Mr. Hunter, please state your name for the record
Billy Hunter,
and your position and your business address.
Right Case Analyst 2, 1000 Center Street, Little Rock, Arkansas.
The same Billy Hunter that filed direct testimony on September 24th of this year and rebuttal testimony and exhibits on November 10th of this year?
Yes.
Do you have any corrections or changes to your testimony?
No.
I'll tender the witness.
Mr. Lewis,
No questions, Your Honor.
and you waive.
Yes, Your Honor.
Yes. Ms. Tate, Ms. Anderson.
Okay, that was what, that was definitely a step further.
It's 4 o'clock somewhere.
Yes, no questions.
Mr. Anderson.
What is that, Matrix? Where is Mr. Anderson? Is that the Matrix?
Mr. Tate.
Thank you, Mr. Hunter. You've sat through this circus today, so I'm going to reward you with a question or two, all right?
Go right ahead.
You heard the testimony today, and you may have had a chance to review the order that Oklahoma denied a return on the CPAs. Are you aware of that?
As of today.
Does that change your testimony at all, knowing that Oklahoma reviewed that as well and denied a return?
No.
A number of CPAs showed up in the RFP that were not selected by OG&E. You have suggested remind me what you're suggesting as the additional sum in this case.
The 20-year Treasury rate.
And is that a snapshot, meaning we'll adopt whatever that rate is today, or does that fluctuate?
That will be determined in the cost recovery.
Okay.
Document.
Given that OG&E didn't select some of those CPAs, do you still think that rate is a sufficient incentive for them to select CPAs or PPAs going forward?
Yes.
Okay. That's all I have. Thank you, Chairman.
I have no questions. You may stand down. Appreciate you, Mr. Hunter.
Thank you.
Thank you. Thank you. Mr. Layson?
Please state your name for the record.
Michael Marchand.
What's your position and your business address?
I am the PSC director. My business address is 1000 Center Street, Little Rock, Arkansas, 72201.
And today, do you have any changes or corrections to your settlement testimony that was filed on November 25th of this year?
I do actually have one change. On page 5, line 1, the word commission should have a little c.
Should I take offense to that?
No, sir, it's referencing the Oklahoma Commission. and I accidentally.
Oh, no, I appreciate that.
I accidentally capitalized it, so I wanted to put them back in their place.
Do you have any other corrections?
No, sir.
I'll tender the witness.
Thank you.
Mr. Lewis? Oh, excuse me. Ms. Chandler? Bring out the big guns.
I think I just drew the short stick.
What's that?
I think I just drew the short stick on
That's
testimony selections. So, Mr. Sean, I have just a few questions I want to walk you through regarding your settlement testimony here today. So you became, as my understanding, you became more involved in this case upon the retirement of your case project manager. Is that correct?
Yes, ma'am.
Okay, and staff witness Bauer was the primary witness involved in analyzing the details of the OG&E analysis supporting HL 13 and 14's project. Is that right?
Yes, ma'am.
And in your settlement testimony, you state that staff's position going into the settlement negotiations was that the commission should approve HL 13 and 14 project on the condition that OG&E instituted customer protection measures.
Can you point me to
Page 4, line 7 through 13.
Yes, that's correct.
And so it's my understanding, and correct me if I misstate this, that you're okay with the project as long as it has the lowest possible cost to customers?
I'm okay with the project as long as there's a reasonable cost for customers.
But your testimony, you stated that you should approve the HL 1314 project on the condition that the company institute customer protection measures to ensure the project is completed at the lowest possible cost to customers, correct?
Yes.
And when you were completing your settlement testimony, do you reference the November 13th Oklahoma OCC order? Is that correct?
Yes.
And you indicated in your testimony on page 4 that you believe the OCC order is relevant in deciding whether HL 13 and 14 projects should be approved and whether any approval should be conditioned upon customer protections in Arkansas?
I stated that, or
You indicated in your testimony on page 4, line 14, and page 5, line 10.
well,
I didn't quote it.
okay, yeah, that's what I was asking. This order came out in between when staff's last opportunity to file testimony and when the settlement was filed, and so I thought that because it involved the resources that we were discussing, it was valid information that should be reviewed. So that's all I was trying to say in this Q&A.
And when you went into this testimony, had you reviewed that order from OCC, that November 13th order? Had you reviewed that order?
It was a cursory review, but I did review it.
Were you aware that there was a dissent as well as a concurrence and then the control, I'll call it a controlling order?
No, I just reviewed the final order, the one that was referenced.
So you didn't review the dissent nor the concurrence before you submitted this testimony?
No, I just reviewed the final order.
And your testimony came out one day after they had filed for a motion for reconsideration in Oklahoma. Were you aware that they had petitioned for reconsideration before that commission?
No.
Are you aware of any instances in past cases where the Arkansas commissioners have simply deferred to rulings and final orders made by regulators in surrounding states involving major utility investments?
No.
Is it your recommendation to the commission that it should simply follow what regulators in Oklahoma and other states decide when considering whether such investments are prudent and in the best interest of Arkansas consumers and the economy here?
No.
And would you agree with me that Oklahoma and other states have different laws and policies that impact their regulatory approval decisions?
Yes.
At the time that you entered into the settlement testimony, were you aware of Bill 460 that became enacted in Oklahoma, where the legislature declared it was in public interest to promote natural gas energy developments in order to take advantage of Oklahoma's vast natural gas resources and compatibility with wind energy?
No.
Do you think the legislator's position regarding these natural gas resources could have played a role and impacted Oklahoma's commission's decision?
I don't know that. Do I think that it did, or do I
Do you
think
think
it
it
could
could have?
I mean, anything's possible.
Do you know, does Arkansas have any type of similar bill here where the legislators have set forth a specific type of generating resource should be given preference?
How do you mean?
So does Arkansas have a bill that says something similar to natural gas should be given preference in the state in consideration by the commission?
Not to my knowledge.
And is it correct that Act 373, the Arkansas Jobs Act, creates special preferences for new generating resources located in Arkansas that facilitate the state's strategy of attracting new jobs, economic development, and industry to the state?
That's one part of it.
I'm jumping around on you because some of my questions have been discussed ad nauseum here today. Yeah, at the bottom of page 5 on the testimony, you state staff witness Bauer expressed concerns related to HL 13 and 14 in his direct testimony, but in his surrebuttal updated his recommendation supporting approval of the project on the condition the company utilizes an IM to review project costs during construction. Is that an accurate statement of his testimony?
Yes.
But the settlement agreement you entered into, does it contemplate the use of an IM?
Not specifically an independent IM, but it does provide for reporting to the commission that would be similar to the reporting that would be given to an IM.
But that's not going to be done by an independent individual?
That's correct, yes.
So that would be the company's individuals providing those documentations? Or contractors on their behalf?
Yes, yeah, the affiliate or the contractor.
Would you agree with me that independent monitors are an important aspect to keeping companies moving in the right direction of low costs?
I mean, I would agree that independent monitors are valuable for many things.
One of which is keeping costs low, or at least monitoring the costs?
When you say cost, that's a very loaded word for me. So I think independent monitors are valuable in evaluating if costs are accurate and reasonable.
Would you agree that an independent monitor should be free to come before the commission and testify regarding any reports they issue?
Yes.
Would you agree with me that an independent monitor in this instance would be a little more stringent than just self-reporting on behalf of the company or the agents of the company?
I don't know that. I think they could be.
The possibility's there.
The possibilities there would depend on the monitor.
And it's also, is it your testimony here today that it's not necessary for the commission here to impose a cost cap or other customer protections because the Oklahoma's final order found the competitive procurement process used was reasonable?
Well, there's a lot of reasons, I think, that don't eliminate the need for a cost cap, but reduce, I think, what a cost cap would provide in the way of consumer protections. And one of the things was that there was such a, robust RFP process, that identified these projects.
In part, this determination's in part based upon the Oklahoma order approving this
That's
project.
correct. Yes.
So if the Oklahoma order takes a different direction on reconsideration, would that impact your opinion?
I mean, I don't know that it necessarily would impact my opinion, but we're not settling then. So, the settlement contemplates the information we had at the time. So, but I mean,
Which included reliance upon the order from Oklahoma.
well, that was something that informed a part of it, yeah. So, it's a really speculative. I don't even know how I could answer that really, that hypothetical.
On page 7, you discuss the settlement, in a settlement concession, that OG&E agreed to make certain changes in its future IRP analysis to consider plant retirements, life extension options, and enforce load forecast accuracy. These future changes, they wouldn't have an impact on the cost of Arkansas customers for the HL 13 and 14 project. Is that correct?
I don't think so. Witness Bauer would probably be better to talk to, but I don't see how it would.
There's something for the future, but not necessarily for the current
That's
time.
correct, yes.
And then on bottom of page 7 and continuing through, I think probably page 9 of your settlement testimony, you talk about the settlement agreement that are related to OG&E's cost recovery of HL 1314 through the strategic investment rider under the Generating Arkansas Jobs Act, correct?
Yes.
Would you agree with me that because this plant is located in Oklahoma, it would not increase jobs in Arkansas?
Not directly.
Would it increase tax revenues in Arkansas?
I don't know.
Would it be creating any economic development within the boundaries of the state of Arkansas?
Not directly.
Would you agree that the selection of a relatively high-cost generation project such as HL 13 and 14 located in Oklahoma is not consistent with Act 373's preference for new generation projects to be located in Arkansas?
Can you repeat that?
Would you agree with me that this project in Oklahoma is not consistent with the Act 373's preference for new generation projects to be located in Arkansas?
Well, I thought I would get through not having to say it, but I'm not an attorney, so I don't know.
No.
I can't weigh in on the statutory interpretation, but
You can give me your opinion, though.
well, I would need to know what specific portion of Act 373 you're referring to. Act 373 was 60-something pages long. I mean, it's got a lot of ins and outs.
Was this project creating a new generation in Arkansas?
It's creating new generation for Arkansas customers. So
It's creating power to benefit Arkansans, but is there a new
Right.
generation facility being constructed in
no,
Arkansas?
no, sorry, yeah.
I think I'm almost finished.
My wife will be happy.
I marked through a lot of it. I'm trying to figure out what I have and haven't marked through. I'll pass the witness.
Mr. Layson, any redirect?
Mr. Marchand, so you said in response to a question there, you said the Oklahoma order informed a part of staff's deliberation process. The way I understood it, but did your review of the Oklahoma order influence staff's decision whether or not to enter into a settlement with OG&E in this case?
No.
Did your review of that order affect any of the specific terms that staff agreed to in the settlement agreement?
No.
No more questions.
Thank you. Commissioner Anderson,
No questions, thank you.
Commissioner Tate,
Well, I can't let him leave without a question.
I
Wait,
wouldn't,
and
I wouldn't
remind-
expect you to.
and remember, he is under oath.
That's right.
And evaluations are ongoing, right?
That's correct.
You did know the address, didn't you?
Yeah, I did. I got it this time.
Just one question, since Mr. Bauer, I think, directed this towards you. Staff previously raised a concern about one of the CPAs and whether it required commission review or not. Can you tell me how the settlement addresses staff's concern in that regard?
I don't think it does. I think,
But to be clear, you don't have a concern about that CPA. It's
No.
just about whether companies could potentially structure things going forward that would evade commission review.
that's correct.
Thank you.
You may stand down, and we're going to take a 5-minute break, okay?
Thank you.
We'll be in recess for 5 minutes. be at ease. We have several things I need to clean up as we move to allowing any settlement witnesses. I doubt there isn't. Yeah. I just want to be sure. Mr. Lewis, we're going to ask you to file the documents you gave to the clerk here with the clerk, and just a letter saying that it was entered into evidence here today, so that we will be able to reference it as a document to the docket. Okay? That's the key.
Chairman, are you asking him to file it through the ECF system?
Yes.
Okay.
Yes.
It is the way it will be done.
Yes. Thank you.
Trying to keep it
And we'll
as
keep it,
clean
you
as we
know,
can.
just that way we've got a duplicate and it's easier for us to reference.
Yes, sir.
Okay?
Would you like to have him identify that when he files it through the ECF system as AG Hearing Exhibit 1?
That would be great. And that it was entered into the record here as well. I'm used to dealing with stone tablets. So settlement witnesses, I know Mr. Chisenhall, you've already presented one and we waived any question. Any witnesses that we need to consider from staff? Okay. Anything we need to consider from the Attorney General?
No, sir.
I think we heard everything. I just wanted to give y'all an opportunity to do that. Okay? We're going to leave the record open for any post-hearing commission questions, but I want to give you a heads up, Mr. Chisenhall. This is something new. Okay? It is likely that we will ask the parties to summarize their testimony today of their witnesses and to file that under oath. Okay? So, of course, we're not giving you a timeline yet. We don't have a timeline, but expect that to come. We've got to get the record, and the order is due, is it, Wally, did you say January 25th? So we're not prepared to really get into the dates there, but and Mr. Chisenhall, we won't have you do it before January 1st, okay? So you can celebrate your holidays and all.
Thank you.
Okay.
Ken, are you through? I don't want to cut you off.
I just want to give you all a heads up there. It'll be something new. We are short-staffed, and we have to call on our fellow attorneys to help us in that regard. Okay? So now you are recognized.
To build on that, if you would, and I fully recognize, and I stated this in my
Oh,
opening
would you go to the
statement.
mic? Go to the lectern. I lectured this the other day. That is not a podium. That is a lectern. A podium is when you stand up here on a raised.
And does one lecture at the lectern?
That's correct.
I'm not going to lecture you.
Thank you.
In my opening statement, I reminded the commission, because I talked about the Oklahoma order and procedure, that obviously you're not bound by that. Everybody's reminded everybody of that several times today. But nevertheless, we have talked about the Oklahoma order quite a bit. We anticipate a ruling coming out of the Oklahoma Commission in the very near future. Would the commission like to have a copy of that ruling, whatever that might be, to supplement the record, just so the record is totally clear?
Mr. Lewis?
I would object to that. That's basically adding an extra exhibit that we don't have a chance to respond to, elicit witnesses from, testimony. We may have other stuff that we'd like to do as well. That's kind of getting to put in evidence after the fact. And
well, we can look at an exhibit of your witness that came in objection to the settlement as that same thing, and I did not raise that.
that's not the same thing.
It is the same thing. It's an exhibit that he prepared objecting to a settlement that was not part of the record
Is it,
before.
was it included as an exhibit?
Yes,
That was, the motion for reconsideration was never admitted as an exhibit.
it's not the motion to reconsider, it was what was
Order?
attached.
You're talking about the order?
Okay.
I'm offering to complete the record.
I hear your statement, I hear your response, Mr. Layson. You want to get into that?
I don't see really the benefit of it, but staff wouldn't object to that.
Absolutely.
Mr. Chisenhall, are you talking about an order on the motion for reconsideration?
Yes.
It was also discussed today about potentially a new application to have the costs associated with the facilities have CWIP apply to those facilities.
Yes,
That would be an entirely separate filing.
it would be, but.
And are you waiting to see what happens on the motion for reconsideration, or is that just on its own timeline?
May I consult just a moment?
You may.
They expect an order on reconsideration possibly by the end of the week. The other pleading, the other motion application in Oklahoma will be filed probably within the next week. And that other motion is the CWIP motion.
Chairman, can I ask a question of the AG?
Of what?
The AG?
Yeah, sure. Yes, you may.
If what he's asking is to file whatever the order is on the motion for reconsideration, what would the AG anticipate needing to file responsive to that?
That's just the point. I'm not really entirely sure because I don't know what may be contained in that. That may bring up new questions that I want to get with my expert about. Unfortunately, I don't know. But I don't want to foreclose the idea. It's a whole order on part of a hearing that we're not party to, and that I don't really get to do much with here in this, in front of this tribe. I can't really do much because it's after the hearing.
And you have those concerns if all that is done is the order being filed with no commentary?
Can you repeat that question?
If all he's requesting to do is to file the order as it's filed from Oklahoma without commentary from OG&E, you still have that objection?
Yes, sir, because again, it could be a 300-page order, obviously not that much. It could be a one-sentence order, it could be a 20-page order. I don't know what would be included.
Is there anything that would prevent this commission from taking judicial notice of that order?
No, sir, there's not.
Absolutely not.
Thank
Well, the offer is well received. It is denied. I think that the Attorney General has made a good point, and the commission can certainly review orders from New York State if we want to. Okay, so no, I know what you mean. It's well received that our parties would not have a chance to look at that. Okay, thank you for the offer. Y'all have been great gentlemen and ladies, and it's been a good day. And I think this is our last hearing before Christmas. Hallelujah! And any motions, anything else that needs to come before us?
For your time.
Okay, we are adjourned. Thank you.
Thank you.